Okay, we are live, we are streaming, we are recording, all that fun stuff. So, have you been checking those out yet, by the way? They're there for you. Just make sure that you go check out impactbrokercoach.com. I pointed a domain name to the YouTube channel just for ease of finding it. You could also plug that in to the YouTube search and find it pretty easily, but it's up to you. And what I'm just doing there, I have almost an entire, I think I might have missed one day, almost an entire pre-class from the fall. I think it was August to October. So that's already on there under the live heading. And then obviously I've been doing these. So I found when I was learning to teach the material back in 2018, I had to get good real quick. I think I might have mentioned to you, and I found the online resources pretty helpful. So look for that. Travis Everett, he's out of a school in Cary. He has material as well. I think trying to think of another name. Just plug in North Carolina real estate pre-licensing, but anytime you hear a discrepancy between what they say and what we cover here, let me know so I can verify what's correct. Hopefully I'm the one that's correct, but I'll make sure if you ever hear anything that doesn't quite jive with what we're talking about in this class. So use those resources, guys. The time will catch up to you before you know it. Hope you've found a groove. Hope you've kind of found that time that you can steal from your normal life and cover this material. You've got to put time into this every day. It's just no way around it. If you don't do it this time, you'll do it the next time you have to try it, to be frank. So look out for that. What else? The syllabus. Let's look at the syllabus. Let's see here. Here we go. It's this one. Nope, that's not the syllabus. This one. This is your best friend. This is going to be my answer whenever you're getting real serious about studying and you say, well, how can we know what we really need to put our efforts on? Here it is. I told you the first day. I will remind you throughout because sometimes people just need the reminder. What we're on now is 2. So let's scroll over to chapter 2. And we're going to finish that up tonight and get on into, I think we'll get through 3 and 4 tonight because you can see the hour commitments. Should take about 4.5 hours for 2, about 1.5 for 3, about 2 hours for section 4. And the textbook that we're using, don't forget, was chosen partially because it coincides with the syllabus. The previous textbook we used was a yellow one, and it was fine, but you had to skip around. So should be easy to match them up. And if we just go down to 2, hopefully, for instance, chapter 1 here, you have printed this off, or if you have Adobe and you can write on here on the screen in your computer, write those definitions. Make a review document out of the syllabus, right? It's going to save you a lot of time. It's going to be a lot more streamlined and efficient for when you're reviewing in about 5 to 8 weeks. So write those definitions, maybe cross-reference, say the page in the textbook that this word came from. You might even make flashcards for yourself, good old-fashioned real paper flashcards. Here's number 2. We got through some pretty weird concepts, and we'll review them in just a moment. But we talked about the bundle of legal rights. What can you do with the property that you own? You have the right to enjoy it, the right to control it, the right to possess it. Talked about appurtenances, things that run with the land. I would write there, out by appurtenance, I'd write runs with the land in quotes, for instance. And that includes subsurface rights, the rights of what you can do under the ground, air rights, as well as water rights, and there are a couple of kinds of water rights. All of these things, you have plenty of space here to reference, take notes, highlight, so use it. You want to fill this whole page up with writing and highlights so that when you are ready to review, starting probably around just after the midterm, you will have covered enough content to have something to review, frankly, because we don't have much to review at this point. So at that point, it's going to be a second set of overwhelming. The first one was right about now, probably. You're looking at this book, you're looking at all this material. You might realize how much reading and studying it's really going to take. What is this, about the third week, Yeah, week 3. This is about the time when the reality check comes in. Some people didn't quite believe me the second week, but now you kind of get it. So, around the midterm point, you're going to want to start reviewing what we covered, maybe cover the new material, but then also circle back to the week 1, 2, 3 and double up so that you can have that review going on at the same time as you're learning new stuff. It's going to make cramming just never works, right? It works very seldom. It causes stress, sleeplessness, and it probably just fatigues you in a marathon exam like this one, 3-4 hours. It's just tough. Why do that to yourself? And I'm a hypocrite because that was my study method of choice, foolishly, in many, many years growing up. We talked about fixtures. That was a big level 3 item. And what is a fixture? Tell me there in the chat. What do I mean by fixture? Oh, everybody put your name in the chat for me too, please, before I forget any longer. Yeah, real property, that's a good word for it. Is it easy to remove a fixture? Can you just pick it up and walk out the door with it? That's kind of a hint, kind of a clue toward what is a fixture. It's attached, screwed in, nailed down. We learned the acronym IRMA, which is not spelled out very obviously, but it's right here. There's IRMA. Because it has to do with if someone sued another person about what a fixture is, somebody took one and they weren't supposed to, so a lawsuit was filed. The judge would say, well, let's see if this fixture passes the total circumstances test. It's not called the IRMA test. It's called the total circumstances test. What was the intent of attaching this thing from the beginning by the owner of the property? Did they intend to leave it there forever? Did they intend to have it there while they used it and then go and then take it with them when they left? What was the relationship of the person who attached it? Are they an owner or are they a renter? If it's a renter, they probably intend on unattaching it, detaching it, and taking it with them. Sort of like when you rent an apartment and maybe you attach a decor item, you screw it into the wall. That's allowed, as long as you unscrew it and fix the holes, probably. You might get your security deposit back a little quicker if you fix it. But they didn't, the landlord didn't mean for you to leave that rack that those decorative plates are sitting on. That rack is screwed in, the plates are laying on it. They didn't mean for you to leave that there. They don't want it. That's yours. You used it while you rented it. So your relationship is a renter in that case. So you made it a fixture, but you are going to take it back. And the method, how is it attached? How hard would it be to detach it? Would it make a big mess? Would it destroy the property? And adaptation, how is it adapted to the real estate? Did you have to create custom cabinets, so some special surround around this item, dishwasher, for instance? And then we, of course, learned about exceptions in the commercial sector of real estate trade fixtures. What's a trade fixture? Speak up if you want to. Tell me in the chat. Either is fine. Okay, I'll give you an example. A hair salon has sinks, maybe about 20 workstations. So there's 20 sinks in there. Is that a trade fixture? Yeah, there you go. Commercial equipment, stoves at restaurants. Good one. Good one. And just so that we can all remember that we are a bunch of humans in the same, at least virtual space, let's take a moment, unmute, and say hello to your classmates. Let's make a lot of noise. Thank you. Hey, India. Everybody, speak up, speak up. Others. There we go. People, there's people. It gets so sterile sometimes because all we hear is me. Who wants to hear that? Thanks, guys. Good. Hey. And again, please feel free. I will keep us on track. If it gets out of hand, I don't think it's ever going to get out of hand. But feel free to unmute and speak up. I know it's super convenient to sit there and watch it like a TV show, but the more participation, the more proactive you are, the more memorable things will be as well. We talked about the difference between manufactured and modular homes. You see what I'm doing here? I'm not showing you those slides again. I will. We'll get around to the slides, but I want to impress upon you the importance of using all the different resources. You really need to be looking at this syllabus every day. Wouldn't hurt to read the section more than once, right? Scan over it once, just out of curiosity to see if you know any of the words and maybe make some guesses in your mind what you think these topics are about. Then read it more closely while making some notes, highlighting, and then fill in the blanks. Create a review document, some combination of those things. Don't be afraid of it. I'm the world's worst at frustration, being overwhelmed. So I'll think to myself in all areas of life, I'll be like, well, if I can't work out for an hour, why bother? While a 15-minute get your heart up, do some air squats would be pretty useful a couple of times a day. Or I only have 10 minutes. I'm not going to bother picking up the guitar. How much good could it do? But that does a lot of good, that muscle memory. And those things do, in fact, have to do with learning things like real estate, because I only have 20 minutes. Why bother opening up the book? Why bother reading over this thing? I'll just read extra long in the syllabus tomorrow. It's those little bite-sized morsels daily that serve you the best, not binging all in one big chunk. And I'm telling myself this more than I'm telling you this, but maybe you can relate. So the question here about the difference between manufactured housing and modular housing is, what does it take to make it real property? That's the testable item out of these things. That's probably what they're going to test you on. Do you know what it takes to make a modular home real property? Because it's not. It doesn't start its life out being real property, does it? It starts its life in a factory somewhere probably far away from the lot where it's going to end up. So that modular home is built in a couple of big sections in a factory to very specific building code and specifications. When it's finished, it gets put on the back of a tractor trailer and hauled to the location. Once it rolls onto the lot, is it considered real property yet? When they roll it, no, not yet. Libby says not yet. They've, in the meantime, while it was being built a foundation. They maybe dug a basement. Maybe they didn't dig a basement. It's just a crawl space foundation. We'll learn what that is in construction. And now it's ready to be sat on this foundation. So they pull it off the trailer with a crane and they set it on the foundation and make sure it's all bolted down. That's the point. If it's a modular home, that's when it's now considered real property. There is no interaction with the DMV. The Department of Motor Vehicles does not care about modular homes because they were never a vehicle. They rode on a vehicle, but they weren't the vehicle. What was the vehicle? The other kind, called a manufactured home. What does it take for that to be real property? That's made in a factory too, by the way, probably very similarly to the modular, but they install a frame like a chassis, like your car or truck has, with wheels and axles and a hitch. Once it's complete, a big truck, a big tractor trailer truck, backs up to that hitch, hooks onto it, and pulls it down the road. And that home is literally the trailer. It's attached. And so now DMV cares about it because it's a vehicle. That home starts its life being a vehicle. Pull it on the lot, it's still still personal property. Put it on the permanent foundation, it's still personal property. You with me? That manufactured housing still personal property because we still have to do three things. What three things do we need to do? We need to take off a couple things and then do one more thing. So I guess that's two things. Need to take some stuff off. What things do we take off of it? Yep, the axle. What else? The wheels. Yep, beautiful. And the hitch, the thing that makes it pullable. And then the other thing, finally, which is the biggest difference between this and the modular, is what? Third step that makes it real property. Yep. File the affidavit with the DMV telling them, look, I took off the wheels and the axle and the hitch, put it on a foundation. Therefore, it is, in other words, no longer portable. I made it real property. Now I'm telling you it's real property. Now it's officially real property because the DMV now knows. I've had it before where the owner did all of those things except filed it with the DMV. And so we couldn't do anything until that owner told the DMV, look, I did all those things 5 years ago. Will you please give me a certificate proving that this is real property so that we can get a bank loan for this property? They wanted to get a mortgage, a second mortgage against the property. That he already owned it free and clear. He paid cash for it, but he wanted to borrow money against it, putting that trailer home up as collateral, so that he could use that chunk of money as a down payment on something I was listing and he wanted to buy. That'll all make sense later. So all those 5 or 6 years, he didn't know. He didn't care. Didn't matter really until it did. But it was really still considered personal property legally. But the bank won't make a loan on personal property and give you real property interest rates. They're not going to give you those nice low mortgage interest rates. They're low. They're higher than they were, but they're low compared to cars and credit cards, aren't they? So that mortgage lender is like, this doesn't look like real property to us. Where's your affidavit with the DMV? And my client had to scramble, and it took a month. Pushed everything back by a month. I had a very unhappy seller who had to wait for this buyer to get a DMV affidavit cleared so that he could borrow money against that property so that he could buy my seller's property. It was a convoluted mess. But it worked. Most things work. As tough as it can get, as angry as some people can be, frustrated as they can be, if we just have to maintain our cool, be the buffer, hold it together, keep people from getting frustrated and walking away. But usually these things do work out. Sometimes they don't, but they usually do. So that's why those things matter. Modular versus manufactured. Now, this part was your worst experience, probably from the last class. Who enjoyed freehold estates? Who's with me? You like the freehold estates? Yeah, no hands. You might even show me a certain finger. I don't know. But we learned kinds of ownership. How do people own things? Fee simple absolute's the best way because you don't have any conditions. And they've got it carved out kind of cleanly here. We saw it in the form of a chart. Let me share a screen with you. Might make it clearer for some of you. And guys, always let me know in the chat if you can't hear anything, if it's scratchy, or if it's blurry. If something is blurry, hopefully, does this look better than it would what it just did? I'm sharing through Zoom, so that usually works a little better. Okay. There we go. That's me. Fee simple absolute, the best way of freehold estate ownership. Then there's the kind that are conditional. Fee simple defeasible, meaning defeatable. And I hope that out beside the category defeasible, you write, maybe out over here somewhere, you write defeatable, because it can be defeated if you don't follow the conditions. If you don't, and those conditions are two things. Either you must keep using it in a certain way, or you may not use it in a certain way. Fee simple defeasible determinable. Fee simple defeasible subject to a condition subsequent. And I hope that you can write out that chart. Use that as a review. Being able to create the chart from memory. I wouldn't say that I have a photographic memory by any means, but I do think of things as images in my head. I'm visual, I guess, in that way. So it's useful to me to see things kind of drawn out. Maybe this will work. There we go. Maybe that's better. So if we had to draw that chart, it'd be something like this. These are all freehold estates. Freehold meaning ownership. And then there's the inheritable ones and the non-inheritable ones. And then out of these inheritable ones, there are three. There's fee simple absolute, fee simple defeasible, and an estate for the life of another, pour aut vie. The defeasible has two kinds, determinable and then subject to. And then determinable means you must keep using it in a certain way, and subject to means you must not use it a certain way. And if you do break that condition, if you break the I'm supposed to keep using it as a farm and you don't, then it automatically reverts back to the owner. Don't ask me how. I don't know the legal process. Auto revert. If you do the subject to one, you're not supposed to ever use it in a certain way. Maybe you're not supposed to use it as a farm, but you do. Then the owner, the seller, well, let me just say it this way. It's not automatic. So I'll say not use, and I'll say not automatic, meaning it doesn't automatically revert back to the owner. They would have to sue you for it. Not the owner, you're the owner. Revert back to the seller, the person that sold it to you. An estate pour aut vie and a conventional life estate are both kinds of life estates. And so both of them have conditions. The difference is an estate pour aut vie is for the life of another, so that measuring life person and the life tenant is the same when it's a conventional life estate, and it's different in this one. So person A, person B. So that means if person A is the measuring life and person B is the life tenant, then the life tenant gets to use it while person A is still alive because they're the measuring life. Therefore, person B could be the one who dies before the measuring life, and they could actually leave it to their heirs. But that would not work over here. Oops, can't spell heirs. So no heirs when it's a conventional life estate because it's the same person as measuring life. So when the measuring life dies, you don't get it anymore. What happens? Who determines what happens when whoever the measuring life is in either one of these cases, when that measuring life dies, what happens to the property? What could happen? One of two things. Yep, it could revert back to the seller, or it could go to a remainderman who is chosen by the seller. So it's the seller who has decided what's going to happen. Seller's decision when that measuring life goes away. And then finally, the other kind of non-inheritable estate is a marital life estate, which really is there to keep a spouse from either leaving the spouse out of the will, or in the event there is no will. Because of this marital life estate, a spouse can't be left with nothing if there's real property. They deserve and are entitled to a certain amount of money depending on the number of years married. That's a big mess. That chart's a big mess. But maybe be able to make it yourself, right? Key points here. There's some that are inheritable versus non. They like to test you on which kind of freehold estate is inheritable or not, to be able to know these differences. Okay. Oh, there we go. That's crazy. Okay, here we go. Let me share this with you. So that was those kinds. And then we'll talk about freehold or leasehold estates later. So we'll get to that in a little bit. Oh, homestead has to do with protecting an owner from creditors, like credit card type creditors. If the owner is behind, not making their payments, for instance, through the Homestead Act, it protects them to a certain amount from losing the property because of owing credit cards and those types of creditors. They still could lose the property because of not paying their property tax. That's always the number one position. We'll learn tonight. In fact, that's like the next topic is lien holders and the priority of liens. If you owe a bunch of different people money, who gets paid first in the case of, for instance, foreclosure? Property tax is the first one that always gets paid first. And then government special assessments. If the government says, hey, you need street lights, you don't want them, but they give them to you anyway, but then they make you pay for them. You and your neighbors, you all have to chip in so many dollars a month to pay for this special assessment because the street lights costed maybe $50,000. So they're going to divide it up amongst everybody. Well, if you don't pay the special assessment, that they could place a lien on your property. Because of that, the special assessment has a second position, meaning if you didn't pay your property taxes, nor did you pay your special assessment, then if you get foreclosed on, the Property taxes get paid first with the proceeds. The special assessment gets paid second. And then all the other people that you might owe get paid after that, which we'll learn later. But Homestead Act has to do with if you don't pay like anything less than the mortgage, credit cards, things like that, then they can't take your property to a certain point. We'll look more into it. We don't do it. It's not as big a thing here as it is, I think, in Florida and some other states. But yeah, that's the idea. Then we looked at the type of ownership, owning something with someone else, co-owning. And when you own something by yourself, it's called ownership in severalty. Whether it's you're by yourself as a human, or maybe you started your own little LLC, limited liability company. That's called an entity. When they say single business entity, they're talking about a LLC or maybe an LLP, a limited liability partnership, where you're setting up a legal person, not an actual human with a heartbeat, but basically a legal person or a legal entity to own the real estate in. That way, if you were, for instance, to get sued, somebody gets hurt on your property and they try to sue you because of that, of course, insurance would have something to do with it. But if you really wanted to be careful, could they sue you for everything you, the person, were worth? Well, the idea is if you own it as a entity, like an LLC, then they could just sue the LLC, not you, the person, because it's not you, the person, who owns it. It's the LLC who owns it. Yes, you do own the LLC also, but that's just the legal acrobatics that you can incorporate. So that's what they mean by business entity. It could also be a C corporation or an S corporation. All businesses, corporations, businesses have or operated in some sort of an entity for the most part. So that's what they're talking about. So it could be a person or a business structure called an entity. You might even out beside entity write LLC, LLP, subchapter S or C corporation. Those are the big four most commonly known entities. So severalty is pretty simple, except the word doesn't make much sense. But if you think of it as sever and not several, ownership in severalty means one person owns it. If you chop something off, there's one piece, right? So sever. Severalty means one. Concurrent is the one that gives a little more confusion because there's three big types of owning things with others. The best and the most common, I guess I should say, the best in terms of the least restrictions, the most flexibility, the best in those regards would be tenants in common or tenancy in common. Because you can do more, you can move it around a little bit more. Married people can own it as tenants in common. They typically own property as tenants by the entirety, but they can absolutely choose to own it instead as this. They can own it any of the three ways. But if they're married when they buy it, the odds are it's going to be tenants by the entirety that they own the property as. But they could choose to do tenants in common. Important points about tenants in common, that's right here, these four. You can own it in different fractions, unequal ownership. So you and I buy it together, but you're going to use more money for the down payment than I am. So you say, well, you're nice and everything, but let's own it 70-30 because I'm putting 70% of the down payment on this place. So I don't want to have a 50-50 ownership. Let's do odd 70-30. Well, the only choice we have, because we're not married, I'm not married to any of you. Therefore, if we buy it together, tenancy in common would probably be our choice if we want to do uneven ownership. Unity of possession. You own it. You own the whole thing together. You can't divide it up. You can't say, well, this half is mine, that half is yours. Don't come over here. Oops, too bad. The kitchen's on my half. Too bad for you, right? So unity of possession means that you share the whole space. And then you can sell or dispose of your individual portion without the other co-owner's permission. when we're talking about this ownership stuff, don't let the word tenant throw you off. Don't think of tenant like renter. They're just talking about the one who occupies it. So just think, when you see the word tenant, don't just automatically think renter. Think of another question to ask. Think, well, what are they talking about? If they're using the word tenant when we're dealing with a life estate, well, that's an ownership thing. Tenant, when it comes to tenancy in common, that's an ownership person. And then what happens when you die? A co-owner who dies in tenants in common, you get to leave your portion to your heirs. It is inheritable. Tenancy in common is inheritable. There is no right of survivorship with tenancy in common. Joint tenancy is a little more like the married version. Tenants by the entirety. So joint tenancy lets unmarried people enjoy the right of survivorship. If one of the owners dies, the other owners get it. It can't go to your heirs. If you want to leave the property you own with your friends, if you want to leave it to your heirs when you die, then this is not the one for you. You need to talk your friends, your co-owner friends, into changing to tenants in common. And they make a note here, we don't use it in North Carolina much. It is used in other states. Therefore, if you see joint tenancy, it'll be on the national portion of the exam. And in North Carolina, in order to create joint tenancy, the attorney would have to write the words very specifically. They'd have to be very careful and use exact wording that came as a result of other things that happened in court. Case law. When you see that something is dependent on case law, that literally means cases that happened, judgments that took place in previous court cases. Case law is developed from when you hear on TV, they talk about a court show and they talk about there's a precedent for that. That means the courts have decided in a certain way. Therefore, it's more likely the courts today and in the future are going to decide that same way because there's a precedent for it. So there's a precedent for the requirement to have very specific wording to create joint tenancy. So if that's what you really want, the attorney's going to have to get it right and really write it properly. There's 4 unities under joint tenancy. You have to buy it at the same time as your co-owners. Otherwise, you can never be a joint tenant. If you buy into it a year after they did, then what are you? What's your form of ownership if you joined in a year later? With me? If 3 people buy a property as joint tenants today, and then next year I'm one of those 3, I decide to sell to you. I decide to sell my portion, my third, to you. Then you can't be a joint tenant. What would you be? Yeah, tenant in common. There you go. There you go. They like to test you that way. That is a very common test question when it comes to this. Okay, little caveat here. See this second note they make mention here? They do say that in North Carolina, the percentage of ownership interest can actually be unequal for joint tenancy, but we're teaching you the basics of what all 3 mean. So for the most part, it's typically going to be equal ownership, but at the end of the day, you can pretty much have an attorney write it up however you want it. But for testable purposes, test-taking purposes, if the question is, which form of ownership is more likely to be equal portions, the answer would be joint tenancy. And then it does include right of survivorship, which means if the owner dies, the surviving owners get the rest of it. So if it's me and 2 others and we're 1/3 each owners, and I die, then it becomes 50-50 ownership by the remaining surviving partners. They make another little note here that in North Carolina, the survivorship feature, right of survivorship, doesn't happen automatically with joint tenancy. The attorney would have to write the language very exactly to accomplish the goal of right of survivorship. But for the most part, joint tenancy includes right of survivorship. Other states, it's definite, automatic. North Carolina, it would have to be written very intentionally. Tenancy by the entirety is the one for only for married people. It is the kind we default to in North Carolina. If you don't, unless you tell the attorney otherwise, they're going to write it up that way. Undivided interest, you of course don't split it up. All of those unities are applicable. You can't sue your partner to sell your portion and cash out, although you can do that on those other two. And if you sell it, anytime you see the word conveyance, if you sell it, both parties have to sign the deed. Both owners have to sign the deed, even if only one of them is on the deed. Even if both are not on the deed, like it's still from when the spouse owned it by themselves before they got married. The married spouse now has to sign the deed, even though they're not married. I mean, even though they weren't the original owner, but they're the spouse now. And a spouse can't convey half the interest like you could in these other kinds. You could sell your portion of joint or tenants in common. You can't do that with tenants by the entirety. And we left off with these types of property: hybrid ownership, hybrid properties. Condominiums. What do you own when you own a condominium? What do you actually own? Do you own the land? No, don't own the land. There it is. Thank you, Libby. Painted surface to painted surface. Not the structure, not the land. You own airspace, really. Sort of like, almost like apartment, but you own it. So a condominium, they call it horizontal ownership because it's like wall to wall, not vertical, not all the way down to the ground. So there's another testable item here. It's about the Condo Act of North Carolina from 1986. The developer has to disclose some things, record a public offering statement, record a plat map, and then give the buyer 7 days to back out of the contract. If it's new construction, make sure you underline and highlight and circle that. The North Carolina Condo Act of 1986 only applies to new construction condos. That one allows 7-day rescission. So I could see a test question being like, John Doe buys a condominium that was built 3 years ago. He gets nervous on the second day after buying it, after closing, or after getting the offer accepted, and decides he wants to back out through the North Carolina Condo Act of 1986. Is that possible? Can he use the Condo Act of 1986? Don't think 1986 is the year built, right? That's just when the legislation happened. Yeah, that was a poorly worded question. I just pulled it out of air. But you get the idea. Make sure you know when you see this, any questioning about rescission on condos, think, are they talking about new ones? Because they better be talking about new condos. Because that's the only time that the 7-day right to rescind the contract applies. And they note here that there's a resale certification through the Condo Act, but that's for resale condos. You would get a certification to resell it, but that doesn't include a right to rescind the contract. And what you own as a condominium owner is a fee simple ownership of the space, but then your tenant in common. You own it as tenants in common for the other space, the common elements, the parts that you share with the other owners. You could have some special portions of common area, like boat docks that not everybody has because they pay extra, or garage space. And the townhouse is dirt. That includes the land it's sitting on. What do you own when you own a townhouse? The structure and the land. And it's a building. It's one of several units in a building. Could be 2, 3, 4, probably no more than 4, because it's still considered residential if it's up to 4 units. And so in between yours and your neighbors is something called a party wall. It's like a double thickness wall with like a fire rating, so that if your neighbor catches their kitchen on fire, it's going to take a while for it to burn through that wall and get into yours. A party wall is a legal term. You own to the middle of that party wall, the wall you share with your neighbor. You own to the middle of it. You'll never see the middle of it unless you take sheetrock down, but that's what they mean by party wall. And then just like with a condo, you get to own and you get to share the use of the common elements with your neighbors, but you don't own them. That's unlike the condo. In the condo, you own it. You co-own it as tenants in common, but in a townhouse, the HOA owns the common areas. And they charge fees. The HOA charges a fee to use the areas and to cover maintenance of the property. And many of those condo units are subject to something called the North Carolina Planned Community Act. A planned community is a multi-use community. It might have swimming pool, tennis courts, not just a single family house, but a neighborhood, an unofficial neighborhood. And then finally, a co-op is something we don't do much around here. A cooperative ownership means that you own a share in the corporation who owns the structure. The corporation owns the building, so you get a share in the corporation, and then you also have a proprietary lease that lets you use and occupy that individual unit. You don't get a deed. You get a lease and a share of stock in the corporation. Timeshare, you need to know about 5 things about the timeshare. 5 things, mostly having to do with the number 5. Timeshare is something that you own the right to occupy for an amount of time. Multiple people can have the same ownership interest in the real estate because you get to use it in July. The next person gets to use it in August, perhaps. It could be deeded. It could also be leasehold. You could lease a timeshare. You could also own a timeshare. And so you get a right to occupy for a certain time period. At least 5 separate times over at least 5 years. There's the big one. Think of it this way. Write this one down. Make a note of it. A timeshare is 5, 5, 5, 10, 5. Remember, 5, 5, 5, 10, 5. 5 separate times over 5 years at least. What if the test question refers to owning it at least 5 times over a 10-year period? Is this looking like a timeshare? Yeah. Just because they throw 10 or 7 or 6, as long as it's at least 5 years, it's still probably a timeshare. I told you for purposes of remembering it to think in terms of like 5, 5, 5, 10, 5. But that 5 I'm talking about is occupying it at least 5 separate times over at least 5 years. But they could say in the test question it went for a 6-year period. Over 6 years, the person used it 5 times. That's a timeshare. The third 5 means you have 5 days to rescind. There's another rescission escape option. You can back out within 5 days of the contract. And then the 10 means the timeshare developer needs to hold the earnest money, hold the deposit money for 10 days. The Timeshare Act is covered in the the real estate license law and commission rules section. There's an entire section about timeshares in that. So you can find the actual rules there. Now let's pick up where we left off. That's about it. And we'll get on into the rest of this stuff in the syllabus. But I'm really hoping to have impressed upon you how useful the syllabus can be. Hey, please, sure. You know, I usually ask the question because everybody does have it in common, at least a negative experience with the big sales pitch in the beginning. I don't know how other states are. I just know that here's another testable thing. In North Carolina, a timeshare salesperson has to be licensed. So I'm hoping that maybe in North Carolina it's done better because of the North Carolina Real Estate Commission having a pretty strict grasp on it. But you know, I guess it is what it is. You get to own something without having to take care of it. It's like an extended repeat right to go to a hotel where you make all the reservations up front. So, but I do hear a lot of people who, and there is certainly a lot of, there are websites designed to help people get rid of them. I guess I hear more negative than positive, just like you probably have. So I don't know. We don't ever, unless you are a timeshare salesperson or developer, I never touch it. I never see it. Never something that I have to deal with. Unless somebody is trying to get out of one in order to get the money from it so that they can, or stop paying the money to it. I don't know if you make any money when you get your rights bought out. I think you just don't have to pay that bill anymore. So yeah, I'm afraid that you might be onto something. I don't know how beneficial it is. I would rather put the money somewhere else, but that's why I think they hire such good salespeople. Good deal for them. It's a great real estate decision for the owner of a timeshare. So maybe be a timeshare developer. Just don't get fined, because that's the last item on that list. $500 fine that the Real Estate Commission can fine a timeshare developer. That's the only type of license holder that the Real Estate Commission can fine. Here we go. Do you see the timeshare slide? Thank you. Perfect. Appreciate that. Make sure I'm sharing the right stuff with you. Okay. So there it is. The way to remember it, 5, 5, 5, 10, 5. 5 times for at least 5 years, 5 days to back out of the contract if you want to, 10 days that the developer has to hold your money, and then they can be fined $500 per violation. Per violation. The Real Estate Commission regulates timeshares, and they issue the developer a certificate of registration. So let's do a little quiz. The owner has the title to the unit and owns the common area with other owners. Which kind of ownership are we talking about? If the owner has title to the unit and owns the common area with their fellow co-owner or fellow owners in the building. Yeah, that's a condo. Tenants in common is how you co-own that common area. But you own your unit outright. It's just you. They don't get to co-own that with you, although you could co-own it with someone. But the thing that you share ownership definitely with in condos is the common area. If you have title to the unit and own the land as well as the building, which kind of structure are we talking about with that? You own the land as well. Which hybrid ownership are we talking about where you own the land? If you own the land, it's a townhome. Townhouses have dirt. If you've ever been in one, or if you ever drive by a new construction townhome community, go inside. Talk to that sales rep. Even if you don't have your license yet, just start learning inventory. Learn what you get. See what's out there. And what you'll see in that townhome community, You don't have to go into the new one to see it, but you'll see a little courtyard behind it. That's because you own the dirt. You also have maybe a tiny little yard behind you. So you own some land with a townhouse. If you own a share of stock in a corporation and then a lease to the actual individual unit, which type of ownership property is this one? There you go. That's the co-op. You got it. And then if you have ownership or leasehold ownership for a certain period of time, what are we talking about there? Ownership for a certain period of time. If it's a time, if you're sharing time with with other people, yeah, that's timeshare. Okay, a trust. With a trust, it's a legal vehicle, so to speak. A vehicle meaning a structure, legal structure where a third party, probably an attorney, is going to act as a trustee. The trustee is the one who gets to determine how it's handled. They handle it because the owner of the property put it in trust for a beneficiary. They're trying to give it to a beneficiary, but that beneficiary doesn't get to make decisions yet. Maybe eventually they'll get all of it. But while it's in the trust, those assets are being held there in the trust for that beneficiary, and they are decisions made about them are made by that trustee. So that trust specifies when those assets are going to eventually pass to the beneficiaries. And it might be, for instance, that someone's parents die. They're wealthy, and they leave the money and the fancy house to their child who's underage, and the trustee determines how to spend that money to pay the bills so that it doesn't just get blown irresponsibly. And then when that child attains maybe legal age, maybe at 21, this beneficiary gets the assets, maybe 25, maybe 30, whatever the owner who's giving them decides, however long they decide that it's going to be. A living trust is held during the life. Testamentary trust has to do with wills. A land trust is dealing with real estate. You could put your real estate in a trust. You could choose to own your real estate in the form of a trust instead of in your own name. If you were to pick a famous Hornet player or a Panther or any rich person in Charlotte or Raleigh for that matter, maybe politicians, anybody really, really wealthy that you can think of. Michael Jordan, for instance, probably owns North Carolina property. He probably has a house in Charlotte or Lake Norman. But I bet it would be tough to find his name listed in the tax records because he probably owns it in the form of a trust because he's rich. And people come after rich people, right? They want privacy, confidentiality. They want liability protection. So Michael Jordan might own his home not as Michael Jordan, but as 23 Forever LLC, right? 23 college number. Some sort of a trust. That would be a land trust because he's owning his real estate through this trust. So anytime you're looking, you can look, the tax records are available to everybody. Look up whatever county you're in, real estate tax, or GIS might be another way you look it up. If you're looking and scrolling through the tax records and you see not a human name, but like ABC Street LLC, they own that in the form of a trust, possibly. They own it as an entity, but it might be held in a trust. Another kind of trust has to do with real estate is called a REIT. Anybody heard of a REIT, R-E-I-T? It's called Real Estate Investment Trust. A real estate investment trust, or a REIT, is sort of like a mutual fund, but what you own instead of shares of stock in companies are shares of stock in real estate. So you co-own real estate. You may never see the real estate itself. You you among many, many, many others own this real estate. You don't make run any decisions on how it's run, the selection of tenants, anything like that. You just own a portion, a share of it, of a REIT. Pretty solid, probably pretty trustworthy because it's anchored in real estate, but that's what a real estate investment trust is. If you're a broker and someone asks you about these things, all of these things are out of our skill set. We could certainly know what they are. We could even maybe tell people might be a good idea for you to consider having your real estate owned in a trust. But beyond that, I wouldn't even say that. If they start asking questions about trusts, tell them to call an attorney. This is legal stuff. This is the territory of law and legal advice. What do you need to know for the test? The words. What's a trust? The one who created the trust is the trustor, or the grantor, the one whose assets are being conveyed. The grantor or the trustor made the trust, and the one they're trying to give the assets to is that beneficiary, because the beneficiary is not ready to be responsible for it yet. Therefore, the third term is the trustee, the fiduciary level person with control over the asset, following the instructions given by the trustor, grantor, owner, giver. When someone passes away and they own things, that process of figuring out the disbursement of those things, as well as checking with the whole world to see if this deceased person owed anybody money, all of that process is called probate. So another term that goes along with this is testate, Testate. Let me put it in the chat. Dying intestate means you died with a will. A will saying, I'll leave my stuff to this person and that person and that person. If you die intestate, that's one word, intestate. That means you died without a will. Those are important words. So probate is the legal process that the person you assign as your executor of your estate, that's the process they have to follow when you die. If you pick someone to be your executor, that's the person that's going to make sure this is done properly. It's not any fun. I've done it. You go to the courthouse, you tell them so-and-so died, here's the death certificate, and they tell you, okay, well, here's the things you need to do. And the things include these. Things like, and this part's not testable for you, but you've got to run an ad in the paper for, I think, 30 or 60 days, something like that, saying so-and-so died. Anybody who they owed money to, here's your time to come forward while we are settling the estate. Because that's the only time any outstanding creditors could have a chance at getting their money that the dead person might owe them. And so during those 30 days is their chance to come forward. And hopefully there is no one. And if there is no one, then good. The stuff left in the estate can be given to the heirs. But there's a chance, there's a little window, that 30 days or so, where some other person who still was owed money could influence or impact how much money goes to the heirs. And you've got to make a list of the assets so that you can put the property through or put the whole estate through probate. And sometimes those assets sometimes those assets include real estate. So distributing the assets of someone who died is called probate. And if someone dies with a will, it's much easier to handle this. If they die without a will, it gets a little more complicated. If they die intestate, now you got to deal with that marital right thing. And that surviving spouse has to prove that they were married to them and therefore they have the rights toward some percentage of the ownership of the property. We'll talk a little more about testate and intestate later. Okay, we know these two words already. Appurtenance means something benefits the land. It's a positive. It's adds to and it runs with the land. You own it now, and so that thing that's the appurtenance is part of your legal right. And when you sell the property, you no longer have that legal right because you don't have that property. The one you sold it to is the one who has that appurtenance because it's related to the property. We'll see what appurtenances are as we go along. And encumbrance is the opposite. It's a burden. It's a negative, some sort of a burden on the land. So there's lots of different kinds of encumbrances, lots of different types of encumbrances or burdens on the land. Any sort of a lien, somebody puts a lien on the property because you didn't pay something, then that's a claim, a legal claim someone has that they have attached to your property. So you owe them money, so they put a lien against the property so that anytime you do sell the property, then they'll get their money. It will have to be paid from the proceeds of that sale. They'll have to be paid. Their lien will be satisfied, hopefully, as long as there's enough money from the sale left over and they have a high enough position among all the other lien holders that there might be. Because if you didn't pay that one, you might have not paid the other ones. It might be like 5 or 6 in a lineup. And some of them might not get paid because you maybe weren't able to sell the property for enough money to pay them all off. I just realized we went past our break. So I'll see you in 10 minutes. Okay, let's bring it back in. Welcome back. So we're talking about things that are burdens to the property. Encumbrances. An encumbrance is a burden. It's a lien. Could be a lien. It's lots of things, but it could be a lien. It could be something that harms or affects the title to real estate. Meaning, if it's affecting the title, then the title is not a clear title. It has a cloud on it. It's a cloudy title. And so that encumbrance clouds the title. Clouds the title. It's something you're going to have to get cleared up. You could sell the property with a clouded title, but it's probably going to either cost you some money or be harder to get it sold because the buyer would have to be willing to take it with that clouded title. It's a problem. So a clouded title is a problem. And so an encumbrance clouds the title. It could be a cloud on the title. It could be the right of a third party, someone who's not the owner. They have a right to use the property, like an easement, like the utility company, because there's a big green box on your property and they have the right to walk across your yard to get to it so they can open it and work on the stuff inside. So they have that right. That's an encumbrance against your property. You can't not let them do it, right? Encumbrance could certainly, as we saw with the clouded title, affect the value or the use of the property. You can't put a fence up that would keep somebody from getting to that utility box because they have a right to be able to get to it. They have an easement, a utility easement. Therefore, it's affecting your use of the property. Maybe you want to put a fence up, but you can't there in the front yard because of that. But here's the big one. Even though it's a burden on the property, just because there's an encumbrance against the property doesn't mean that you're not allowed to sell it. You could sell it with an encumbrance on it. That's a testable item. Could you sell a property that has an encumbrance on it? Yes. It's just that you're going to have to find a buyer willing to deal with it, willing to put up with it, who's okay with that encumbrance being against the property. But no, it doesn't prevent you from selling it. You could still sell it. You might have to sell it at a bit of a discount, and it might take you longer to find the right buyer. So, a lien is one type of encumbrance, but there are many different encumbrances that we've seen a few of them, and they weren't all liens. So all liens are encumbrances, but not all encumbrances are liens. Let's look at some words. Here are some examples of encumbrances. Encumbrances include liens, which means you owe money. Therefore, you can't sell the property without paying back the money you owe because it's going to be on the record. It's recorded. The lien is recorded and it's against your property. And whenever you do try to sell your property, and let's say that you are supposed to get $100,000 from the sale proceeds of selling your property. After you pay the agents, after you pay the closing costs, and for whatever you sell it for, you're going to end up with $100,000. But you have 3 liens against the property from other people. One of them is a property tax lien for 1 year, and your taxes are $3,000 a year. Well, you're not getting that $100,000. You're going to get $100,000 minus the 3 because there's a tax lien that has to be settled. So your proceeds are going to be put toward it. And maybe you owe a roof contractor. Somebody put a roof on your house for $18,000 and you didn't pay them. Well, guess what? Now that $100,000 you were supposed to get when you sold your house, $18,000 of it's going to go to pay that roofer because they put a lien against the property. And maybe the city decided that your street needed to be repaved, and therefore you needed to contribute $5,000 toward that repaving. And so they levied a special assessment where you had to pay $300 a month for the next however many years. We'll cover that 5,000. I can't do the math in my head that quick. Well, guess what? Now you got to pay 5,000 more from your proceeds. So now what did I say? 3,000 plus 18 plus 5, that's 8 and 18, that's 26,000. So now you're getting 74,000 from that closing, not the 100,000 you thought. Because 26,000 of that was put toward paying off those liens that were attached to it. That's a great question. Brian says, what if they owe more than the house is worth? Well, welcome to 2008. That was a very common conversation we had on a listing appointment. No fun. We had to go in there and find out how much did they owe, because they owed $200,000 to their lender, but the bad news we had to give them was the house was only worth $180,000. And then they also have liens on it. Well, now they've got to ask permission from their lender to sell it for less than what it's worth and pay the lender back less than what they owe them. So you've got lots of issues there. When it comes to that issue, that's called a short sale. We'll learn about short sales later. But one thing that the lender could do, the mortgage lender, is attach a judgment on you, the person. So when you sell the property, even if they allow you to pay them less than what you owe them, they could say, well, we're going to be nice, but not that nice. We'll let you sell the house for $180,000 and pay us back maybe $15,000 short of what you owe us on the loan amount, but you're also going to owe us another $5,000 at some point. And that's a judgment, a deficiency judgment against the person. So that could happen too. It's a mess. It could be a real mess. So these are three types of encumbrances: liens, easements, and encroachments. Liens is about money, collateral for unpaid debt, putting that debt against your house. Easements are like the utility company, being able to access a portion of your property to get to their boxes, to get to the power poles, to get to whatever the utility thing is. And then an encroachment is when you or your neighbor's improvements cross over the property line. So let's say you built a 3-car garage, detached 3-car garage, because you have a car you want to work on and do some restoration, and you have a wood shop. That's what I would like, is a garage that would accomplish those things. But you didn't get a survey done before you had it built. And so they built this structure, this 3-bay garage structure, over the property line. That is an encroachment. You are encroaching onto the neighbor's property. This could cloud the title, and this is an encumbrance that would need to be handled when you sold the property. You're going to tear down the building and move it, or are you going to maybe see if the neighbor will either sell you that little sliver that you're over, like by a foot, or maybe sign something saying that they don't care forever and ever. You're going to have to work something out in order to sell it with an encroachment. Or it's just as much of a problem if it's your property, driveway, building, fence, house. If it's your property over the line onto them, or if them over the line onto you, still a big hassle. Those are encroachments. All of these three things and the various examples of them are encumbrances. They are all burdens to the property. Here's some other ones. What's a burden to the property? Rules. Rules of what you can do with it, called deed restrictions. Deed restrictions, sort of like the whole fee simple defeasible thing. A deed restriction, like you must use it as a church. You can't sell alcohol. Those are conditions, rules, and therefore encumbrances, limiting your use of the property. Restrictive covenants are kind of similar, except instead of a restriction on your specific individual deed, restrictive covenants are a list of rules and guidelines that the whole neighborhood has to follow. So if you live in a certain neighborhood, there may very well be restrictive covenants. Even if there's not a homeowners association, there could still be restrictive covenants for the neighborhood. We'll get into those in Unit 6. And then some legally specific types of encumbrances are these. A lis pendens. Lis pendens, think when you see pendens, the word pending. Pending means in the process, right? It's in the works. Therefore, in other words, a lawsuit in process or in the works. It's not been decided. It's in the court system making its way through. Therefore, the encumbrance is against the property while this court decision is being made. And that court decision could result in a lien, for one thing, could result in different things against the property. So if a lis pendens is against the property, it's an encumbrance. It's acknowledging to the world that this property could be affected by a forthcoming court decision. There's something being pursued in a court of law that could affect the title to this property. That's a lis pendens. A writ of attachment or any sort of pending lawsuits, all of those things are that type of legal decision that could affect the property itself. So let's specifically look at liens, because that's something that comes up a lot. A lien is something that says that you owe money to someone, therefore your property is going to have to be burdened over it. You can't sell the property without paying off the lien. That lien holder, the person you own, or the company, the person or business you own, or the government, to whomever you owe the money to, that doesn't mean they can come in and watch the game, come in and sit down in the best chair and hang out and possess the property, but they are a third party that gets a chunk of money if you ever do sell the property. Two kinds of liens. Liens are in these two categories. Think happy and sad. Voluntary lien, think happy, because you agreed to put this lien on the property. What kind of lien could you imagine that you'd be happy about putting against the property? What kind of lien would be a voluntary lien? Yeah, that's a good one. A mortgage or a refinance or a home equity line of credit. All of those are types of mortgages. A second mortgage, a primary mortgage, because you're not getting that loan unless you put the property up as collateral and allow them to have a lien. They have a lien. It's a voluntary one because you were happy about it. You were happy about it because otherwise you couldn't have bought it. Most people can't buy a six-figure or more property without borrowing money. And so they agree to put this lien against the property. Once you sell the property, you can't just keep making those mortgage payments and never give them their big chunk that you owe them. You got to pay that lender off in full if you choose to sell the property. That mortgage has to go away and get paid off from your proceeds. You don't get to take the entire $300,000 proceeds without first paying the loan off, the mortgage for $180,000. You're not getting $300,000. You're going to have to pay off the loan because there's a lien. And you agreed to it voluntarily. It might have been for a primary mortgage in order to buy it to begin with. It might have been that after an amount of time, you've built up some equity in the property so that if you sold the property, again, you could pull out, let's say, $200,000 of your equity. And if you have $200,000 of equity in the property, you could probably borrow 80% of that in what's called a home equity line of credit, which is which is sort of like swiping a debit card, and every time you do, it reduces your equity in the property until you've used up that entire HELOC, home equity line of credit. It's essentially a second mortgage. But again, voluntary lien. You chose to do it. The involuntary lien, think sad face. We're not happy about it. We knew it was possible, but here it is. It's because either you didn't pay when you were supposed to, or there was a judgment from a lawsuit, something or other has enacted this involuntary lien. And so now there's a lien on your property for not paying your income tax, or not paying your property tax, or not paying the special assessment, or not paying the plumber, or not paying the on and on and on. right? An involuntary lien represents a tax lien, foreclosure, any of those things. Now, when we decide who gets paid first, let's say you owe like 6 different places. You've got 6 different kinds of liens against the property. Which ones get paid first? That's the magic question. They can't all get paid probably. Quite often, if someone's in that bad a shape, the property when it sells is only going to make them a certain amount of money, and maybe the amount that it makes them can't cover all of the liens. By the time they pay off the mortgage, they also owe the IRS, they also owe the property tax, all those liens. Property's just not worth as much like we talked about it a minute ago. And here's what happens. It's called lien priority. Ignore the one that says superior liens. It's not really a category, and I don't even like it being there. In fact, I'm going to change it right now. I saw it before and I didn't change it. Let me move that. Because it's just not, I think it's confusing. Okay, here we go. All right. Can you see that? Lien types? Give me a thumbs up. Okay, good. Thank you. So, specific liens mean liens that are specific to the real estate, to the property itself in question. It's a lien against that property. And when that property sells, that lien has to be paid from the proceeds of that sale if the money is there to be paid or available to use. Specific liens, we'll see what those are in a second. General liens are not specific to the property itself. They include both your real and your personal property. And you. Things could stick to you. So specific liens include these. Property tax, because that's about the property itself. Special assessments, because that's against that specific property. A deed of trust is another word for a mortgage. So the mortgage you used in order to buy the property, that would be a lien against the property. A mechanic's lien is for any work that was done by a contractor on the property, for the property itself. Therefore, it's also in this category of specific liens. And then something called a commercial broker lien that we'll learn about in a second, but that's against the specific property as well. Any of these liens are going to need to be paid from the proceeds of the sale because they're specific to that real property. A general lien is against all of your property, not just the property that you live in or in question, but your personal property too. That includes judgment liens. You lost a court case, somebody sued you and a judgment was put on you. Even though you sell the property you live in, this judgment lien is still in place and against you. It didn't necessarily get paid off from the sale of the property. A personal property lien like a car tax that you didn't pay, or North Carolina Department of Revenue, state income tax, as well as federal income tax. Notice this. Both state and federal income tax are general liens because they're not necessarily they're not about your property specifically, they're about you. You own your property, but these liens would be against you. So look, they're in this bucket. Think of it as 2 buckets. They're in the bucket of general liens. But what do we say back here? There are 2 buckets, specific liens specific to the property as well as general. And these are in order, guys. These buckets are in order of priority. Specific liens get paid before general liens. Think about that. What are specific liens? These things: property tax, special assessments, mechanics liens, work done for the house. And then these are general liens. Would you have ever guessed that the IRS may not get paid first? We always think that's the ultimate authority. Got to pay your income tax. Well, you got to pay your property tax first. And if you got an IRS lien and also a property tax lien, the property tax lien is getting paid before the IRS lien. In fact, all of these liens over here, these specific to the property ones, all of them are getting paid before the IRS lien. That's an easy one to get wrong because we're so conditioned to think, ooh, IRS, yikes. Got to pay them before all else. Everybody else will know. They're a general lien. And general liens come second. So these are the specific liens. What about this thing down here called a mechanics lien? Okay. Let me pull something up that might be a little easier to note, to recognize. A mechanics lien is about work that has been done on the property. And let me see here. Right. Mechanics lien is what a worker who did work on your property could do to make sure they get paid. Here we are. Oh, good. It's okay, good. There we go. Hopefully you can see that. Can you see that pretty clearly? Okay. So this is available to you. It's in the Notion classroom, online classroom. I put this together because I think this is one of those times where a visual is your best shot at remembering these things. So a mechanics lien. Let's say that you had plumbing work done. A plumber came and did work on your property on August 3rd. They started work on your property. It could also be the date at which the materials were first delivered. So either did work or had materials delivered. The first date that either of those things happened, in this case, August 3rd. Well, on August 17th, maybe the plumber gets a funny feeling that you're in trouble and you're not paying your bills. So she stops doing work on the property. The date that the mechanics person or the vendor or the contractor stops doing work on your property is an important date. Because the whole thing about mechanics liens says this plumber has 120 days from the time she stops doing work on the property, during which she must file the lien. If she wants to bring a mechanics lien against your property, she has 120 days to do it, to file the lien after the last date of doing work on it. That's the yellow. So she has until December 16th, which is that 120-day mark from the last time work was done. And what can she do during that 120 days? File the lien. Once she files the lien, it locks in her place in line, her lien priority. What is her place in line? It's not the 17th. It goes all the way back to the first date she started doing work. It's just that she had 120 days from the last date to file the lien. Does that make sense? How much time does she have to file the lien? 120 days from the last date the work was done. But then the date she's got, her placeholder, her place in line, would be the first date she either did work or provided materials. So if the person whose property it is didn't pay her, but they also didn't pay a roofer, and the roofer decided to file a mechanics lien, but the roofer didn't start work until August 5th, then the plumber is above and ahead of the roofer. If there's any money left when the property gets foreclosed, for instance, the plumber's getting paid before the roofer is. And it might be that was the last little bit of money there was, so the roofer might just be screwed, gets nothing. So it's important to hurry up and file. Now, the 180 days in purple runs, if I did my math right, it'll be close. But 180 days, again, from the last day work was done, as long as the plumber can prove that she filed the lien within the proper 120-day period, then she still has the right to pursue the legal action. Just because she files the lien doesn't mean she's coming after the owner and enforcing the lien. Enforcement of the lien is 180 days within the last date. Filing the lien is within 120 days from the last date of work being done. So this enforcement, this pursuit of court action against the owner, last little column there, must be done or initiated within 180 days of the last time she either provided materials or did work. Do you get that? I feel like you're going to have to see this like this, maybe even recreate it yourself to really grasp it, because it's weird, a lot of moving parts. It's like, is it the last day? Is it the first day? The 180 versus the 120? And what? What is this? So, when does she have to file the lien? At what point? What is it about when she must file the lien to place a mechanics lien against this property? There you go. Beautiful. You got it. And once she files the lien, what place in line has she locked down? What is her place in line according to date? She files the lien. Now her place in line is the date the first work or materials were delivered, in this case, August 3rd. You got it. So it'd be easy to confuse it and think your place you're locked in is that last date. So just be careful about that. And then filing the lien is just putting it on record, saying, look, I might need to enforce this, but here it is in place just in case I do. She could file it, and then the owner catches up, maybe decides, wins the lottery, maybe gets their own paycheck that they were waiting for, and they're able to pay her off. And now she can remove the lien and didn't have to enforce it. So she got paid regardless of the lien. But in case she does need to enforce the lien, it must be filed first. So what they like to do on the test question is give you some dates and make you add up those dates and think, did she file in time? They'll ask, what place in lien priority does she have? And if when you add up the days, if you discover that she did not file within 120 days, but maybe in 130 days, then she has no place in line. Write that one down. That's one they like to ask. They'll give you a scenario. They'll say so on and so forth, did electrical work, and the last day was August 17th, and they filed a mechanics lien on December 30th. What place in line of lien priority does this electrician have? None, because they filed outside of the 120-day window. You with me? That's what they like to do to you. So know that 120, 180, that's there in the notion for you. All righty, let's see. And so this says the same thing. I just hopefully made it a little easier to understand. Here's another example. First day of labor and materials was February 1st. Last day was June 1st. They filed the lien on September 30th. So did they file within 120 days? What's 120 days from June 1st? That's all of June, all of July, all of August, June, July, August, all of September, August, to September. Let's see. To July 1st to I can't remember how much. June to July to August to September. To September 1st goes 90 days to October 1st goes 120 days. So they're just within like one day. They had one more day. So it looks like they did, and therefore now their place in line is February 1st. And did they enforce the lien in enough time? Again, count the 180 days from that last day of work, June 1st. So to July, to August, September, October, November, December. That's 6. Yeah, that's 6 months, 180 days. So again, they just beat the deadline there too. Stop. I'm going to redo the share because I couldn't see your faces. Bear with me. My goodness. Okay, let me know in the chat if you can see commercial broker lien. I think you can, but it's somebody give me a thumbs up. Yep. Okay. Thank you. All right. Commercial broker lien. Wouldn't it be nice? I'll tell you a quick little story, a real life story. I listed a house by a guy, and this was way back in the day, 15 years ago, when it took a little while to sell property. And I met with him and he said, here's my retirement plan. I want to sell this house. I want you to help me sell it. When I sell it, I'm going to buy an RV, a pull behind RV, and a big, nice truck to pull it with. And me and my wife are going to drive across the country, and that's our retirement plan. I thought, great, good for you. So I put the house on the market. Oh, by the way, this was around 2010. And so I had to have that natural part of the conversation. I had to say, now, what do you owe on the property? Because let's make sure that you don't owe more than the house is worth. And we found that it was real close. He might have gotten like $1,000 from the proceeds, or he might have even had to bring $1,000 and pay out of his own savings to sell his house because it was so close to what he owed versus what it was worth after paying expenses like commission and whatnot. And he said, that's fine. I've got the 1,000 or a couple of thousand if I need to pay at closing, as long as I can be done and go forward with my plans and buy this truck and RV. And okay, great. And we put it on the market, and 3 months later, which was a pretty normal time on the market, we got an offer. And we worked it out on the phone back and forth, me and the other agent. Hey, what about this? What about that? And we came to a verbal agreement. And so I went over to his house to get him to sign the paperwork, to sign the contract, to sign the offer, to make it a contract. And when I got there, there was an envelope on the table, and it said Bank of America Short Sale Department. And he said to me, well, I've been reading up about this, and I want to do a short sale. And my heart sank because he should have told me that 3 months earlier. If you use a short sale, if you try to get a short sale from your lender, remember, that's when you're asking your lender, you're saying, hey, lender, I probably can't sell the house for enough money to pay you back. Will you let me pay you less than what I owe you? Sell it short of the full loan amount that I owe you. You can't put the house on the market if your seller's trying to do a short sale without telling everybody. It's a material fact. I would have had to tell the whole world, I'm selling this property, but it's going to be a short sale. We've got to wait a certain amount of time. We have to see if the lender will allow the short sale. That's part of the process, and it can take a long time to get that permission. It could even be in like 6 months to a year. And that's something a buyer deserves to know. Wouldn't you, if you're buying a house, want to know that you might have to wait a year to even be able to close on it because the seller is doing a short sale? Well, I said, remember we talked about this 3 months ago. Specifically, I said, how much do you have money to pay everything off, even if you had to bring money to closing and not get any? And we specifically talked about short sales. He said, I don't care. I want to do it now. And I said, well, I'll tell the buyer, but since we didn't disclose it to him like we were supposed to, since I didn't know, he may very well walk away because he might not be able to wait so long that it requires when you're doing a short sale. My guy said, okay, just ask him. And so I did. And he said no. First of all, the agent reamed me out and said, you're supposed to have told us. And I'm like, I know. I just had to take it because what could I do? And he walked away. The buyer said, no, I'm not trying to buy a short sale. If I'd known it was going to be a short sale, I never would have made an offer. Understood. I get it. And it's exactly what I expected. Went back to talk to my guy, and he said, well, actually, that's okay with me because I've been talking to an attorney. And you know what? I went ahead and bought, and I did notice like the week before, he had gone ahead and bought the RV. He bought the truck and the RV. He went ahead and bought them. He talked to a bankruptcy attorney, and that attorney did such a good sales job about how great bankruptcies are that this guy was happy about declaring bankruptcy. And so I had spent 3 months trying to sell his property. He's declaring bankruptcy. That means the listing goes away. That means Neil gets screwed, paid nothing. Wouldn't it have been nice if I could have put a lien on his property to pay me my commission that I deserved because I brought him a ready, willing, and able buyer? It would have been nice. But there is not a residential real estate broker lien. That was a residential transaction. So I couldn't put a lien on it. There is something called a commercial real estate broker lien, however. So if it is commercial real estate and a broker feels like they're not going to get paid, they've done everything they're supposed to do, but the seller is not going to pay them. Again, commercial property only. The listing broker who's listed that commercial property can put a lien on it. So when that seller ever does sell the property, that broker's going to get their commission, hopefully, if they're high up enough on the list of lien priority. So that's what it is. A commercial real estate broker lien lets the listing agent put a lien on the property if the seller looks like they're not going to pay him his commission. It's got some specific rules required. Again, commercial. Second, must be the actual listing agent who has a written agency agreement all in writing officially. And it's for placing a lien on the property that's going to be sold or leased in order to protect the commission of that broker. We'll get more into that in one of the post-licensing classes you'll be taking. All of these were this kind of lien, specific to the property, specific liens. Now let's look at the next group, the general liens. Here they are. We've seen this slide once before. General liens include judgments against you, the person, IRS liens, both state and federal, personal property tax liens. All of those are against not only your residence, your real property, but also your personal property. And so these items in this bucket of general liens get paid after the ones that are specific liens. What can happen to your property? You could still sell it with a lien on it. You can sell your property even though it's got liens. It's just that the buyer is going to be the one who has to pay those liens. So therefore, do you think that buyer is going to be willing to pay you the market value? Are you going to get as much for your property as you would with no liens? No, because that buyer is going to need to pay you less so that they can afford to cover those liens he's going to have to pay off for you. He's the new owner, but he's going to be the one to pay those liens. Therefore, he's not going to pay you top dollar. He's going to want a sizable discount since he's having to pay off your trash, your liens, right? So the value of the property would be probably reduced because of the lien rights that are attached to the property. And you can sell it to somebody as long as you tell them what you're buying is this property. with liens attached, subject to unpaid liens. So, does an encumbrance or a lien prevent the transfer of property? Does an encumbrance or a lien prevent you from selling your property? Put that in the chat for me. Everybody participate. Give me something in the chat. Thank you. Yeah, correct. No. Yeah, the grantee, the buyer can't refuse an easement as an encumbrance, for instance, and they could agree to assume the responsibility for a lien. They're just going to be expecting to pay a lower price for the property. We come back from break, we'll look at a little example about the lien priority. So I'll see you in 10.
Don't want to buy, they want to rent. It's BS. The numbers show
Welcome back. Let's bring it on back together. Finish this exciting conversation about leans. Oh my goodness. The technology is winning at the moment. Okay. Who gets paid first? Within those specific lien bucket categories, within that one bucket or the general, but within any one of them, who gets paid first? So we're talking about specific liens this time at this point. First of all, you should know that regardless of who filed when, the first position lien holder is always the property taxes. If someone has not paid property tax and a bunch of other people and liens, a lot of liens are on the property tax is getting paid first every time. So on the test, if they ever say, what's the priority of the following liens, you need to weed out the answer choices and pick the ones that have property tax in the first position because it's always first. Property tax first, special assessments by the government second. What are special assessments by the government? Could be street lights, could be paving the road, could be putting in sidewalks, could be putting in sewer lines, anything that's for the good of the public that they need to put in, and they're going to charge a special assessment to those owners that are benefiting from those things. That's a government special assessment. You could have an HOA special assessment too, by the way, but that's not the second position. The government special assessments is the second position. So property taxes first, government special assessment second, and then the specific liens, the rest of them, in order of when they were recorded. Remember, recording means you go to the courthouse, to the register of deeds, and you record a lien, and you say, I'm putting it on record that this is something this person owes me. So the order of when they were recorded, order of recordation. Then the general liens in order that they were recorded. Does that make sense? So in North Carolina, it's called a race state, a pure race state, meaning race to the courthouse and file your lien first so that you beat out the others. That's what it is. Get to the courthouse first, file your lien so that you can get paid while there's still money, because they might run out of money before they get to you in the list, in the order. Okay, these are mixed up. The order of these liens they're not in order. So take a look at these liens and tell me, put them in order in the chat. Tell me what order would be the correct order these liens will be repaid in the chat. What order, who gets paid first out of this list? You can use abbreviations. And let me clarify. Obviously, property tax, pretty clear what that is. Mechanics lien, we know what that is. Mortgage, easy. IRS lien means, of course, federal income tax. State tax means the state income tax. State tax, that's not property tax. That is the taxes you have to pay to North Carolina for making money in the state of North Carolina. So that's basically the state IRS, but that's not what you call it. It's the State Department of Revenue. Property taxes first. I think everybody got that one. Definitely property tax first. Now let's see what's left. Which of the ones that are left are specific to the property? Which of the remaining 4 are specific liens, not general liens. There's 2 of them. 2 of the remaining 4 are specific versus general. Mortgage is one of them. Good job. And the mechanics lien is the other one. You got it. So those are the next 2. But which one would come next out of mortgage and mechanics lien? The one that was recorded first, right? Which was the mortgage, because it says recorded July of 03 versus August of 07. And then the mechanics lien. Now the general liens. IRS and North Carolina Department of Revenue, which one of those will come next? The next one in line, according to date, chronological order, state tax, North Carolina Department of Revenue, June 01, and then finally the IRS, federal government, October of 01. That's it, right? Property tax always first, then any specific liens, then any general liens. And then within the specific liens, in order of recordation, within the general liens, in order of recordation. And then a little reminder note that a mechanics lien is given the date of recordation where the first materials were delivered or first labor was done. Okay. Other kinds of liens. A writ of attachment, some sort of a court order that was filed against you, creates a lien. The court issued an order that puts a lien against you against the property. That's a writ of attachment. So we had talked about all of this conversation came up because these are types of encumbrances from back here. Encumbrances include liens, easements, and encroachments. Let's move on. Next, private deed restrictions, also encumbrances, burdens on the property. These are private deed restrictions, not the government saying what you can do with it, but some person saying what you can do with it. What are they saying? They're saying, here's what you need to do to live here. You can't, you bought this lot to build a house on? Well, the private deed restrictions say that you have to build a brick single-story house here. You can't build anything different than that. It's placed privately. It's also enforced privately. If you don't comply with these private deed restrictions, what's the enforcement of that? If you don't do it according to the restrictions, if you try to do your own thing and not follow them, who can enforce it? Anybody can sue you, right? The developer, the homeowner association, other residents, your neighbors could say, she's not doing what she's supposed to do. In here, the deed restrictions say fences can only be 6 feet tall. She put in a 10-foot tall fence. I'm going to sue you. You're breaking the deed restrictions. So you could be sued. As opposed to like a zoning law that you violate, a public land use control, they would send you a letter. They would eventually fine you probably. But a private land use control is this, a private deed restriction. It could also be a stricter requirement or condition than zoning laws are. The zoning could have a certain thing, but the private deed restriction has another thing. And what we'll see in this course, at least three different examples, is that the stricter thing always takes precedence. It doesn't matter who it is. If the federal government has a requirement of you versus the state, and it just so happens that the state requirement is more strict, then it's the state one you have to follow. Doesn't matter that the federal government's bigger. Or if the state has a building code and then the local city that the property is in has a more strict code, you've got to follow the more strict one, even though the state is bigger. That doesn't matter. The strictness is what matters. You'll see this several times. The stricter of the two always applies. A lis pendens, we talked about it. Recorded notice that there is litigation or a lawsuit pending. It's in the works, hasn't been decided yet. They're thinking about it. And it's tying up the property, the title to the property. It clouds the title, but you could still buy it. You could still sell it to someone, as long as they're willing to sell it subject to whatever the outstanding litigation results in, right? In order to quiet a title or clear up a clouded title, here's the order of events. Notice of quiet title suits. First, a lis pendens would be filed. Recorded notice of litigation, that there's litigation affecting the title. Second, a court hearing happens. The judge affirms any valid claims and puts to rest or quiets any invalid claims. And then third, the court rules. The judge rules and hopefully clears the cloud. Looks at the situation, the matter at hand, and perfects the title or clears the cloud. That would be the process to clearing up a title dispute or some sort of a clouded title situation. Who always gets paid first from proceeds of a transfer? Like if there's liens involved, who always gets paid first? You got it. The government. And then everybody else gets paid according to the order in which they filed. Order of recordation for specific liens, and then order of recordation for general liens. Other kinds of encroachments or encumbrances include easements. Those boxes, those power lines, the utilities companies can have a right to come and service these lines, access them, to maintain them, keep them in good repair. So therefore, they have a right to use your land. Not the whole thing, but just whatever it takes to get to their property, to get to their boxes and their power lines. It's not ownership. It's just the right to use a portion to access what they need to. It's an easement appurtenant. Easement appurtenant. Appurtenant means it runs with the land. Easement means some third party has the right to use it. And it's given to parcels of land. It benefits that land. Access to those boxes. Driveway easements. Utility boxes. Another easement appurtenance would be this, where you have a street and this property in the back is landlocked. They can't get to the street without crossing over the property in front of them, their neighbor in front of them. And so the one who needs the access, the one in the back, is called the dominant estate. This would be easy to miss on a test because you're thinking, well, the one in the back is the one at a disadvantage because they're landlocked. They can't get to the main road out there. Well, they can get to the main road because it's required that they have a thoroughfare or access to the main road. It's illegal in North Carolina to sell landlocked property. No property, no land can be blocked off from the road. If you were left 100 acres, or let's say like 3 acres from your grandma, and now you have this property and you want to carve it up into lots, and maybe it's shaped weird, you can carve it up maybe, but you've got to make sure that however many lots you subdivide it into all have access to the street or to the road. You can't leave them landlocked. And so that estate that is getting the benefit of this driveway on the far right is called the dominant estate. They're receiving the benefit of the driveway access. The driveway, if you'll notice, goes over their neighbor. The property that it's going over is called the servient estate. So dominant and servient. Think dominance, servience. And that driveway is an easement that goes appurtenant with the property it runs with. If you sell, this dominant estate owner sells to the next person, they too have a driveway easement. That didn't go away. It runs with the property. It's required. There's also something called an easement in gross. And so instead of attaching to the land, it attaches to an entity or an individual, like a railroad company. They don't own the land those tracks are on. They own an easement in gross, the right to build across the land because they need to put those tracks down, which benefits the public. It's granted to an individual or a legal entity. It benefits that individual, doesn't run with the land itself. If that individual goes out of business, that easement in gross is gone. It would be given maybe to the next individual if they bought the business, perhaps, but it's not something that runs with the land like a driveway easement, which is a easement appurtenant. So easement appurtenant versus easement in gross. Easement appurtenant runs with the land. Easement in gross runs with the person or owner. So you could have both. Here's the easement appurtenant driveway on the right, and there's the utility easement, railroad tracks, or maybe drainage, all considered easements in gross. They're given to those entities. How can easements be created? Usually in writing. That's certainly best. But just because it says express doesn't mean in writing only. It could also be verbal, but the best way typically is going to be in writing because now you have something enforceable. If you don't write it down, it's not something you could take into the courtroom and prove. So it needs to be in writing in order to be enforceable. But the word express means you're expressing your intentions. Here's what I want to accomplish here. And express could be either in writing or verbal. But for easements, we're going to write it down. Implied easements are when it's needed because of a situation or a circumstance of access, like the easement appurtenance for the driveway. That was an implied easement. You've got to have it. You can't have a landlocked property. You could also have an easement that is by operation of law. Something called eminent domain. Anybody heard the term eminent domain? That's when the government can basically buy a portion of your property or maybe your whole property, basically take it from you, condemn it, take it from you, but not just steal it. They have to pay you fair market value for it. Whether the owner thinks that it's enough remains to be seen. That's probably the case. The owner probably thinks they should have been paid more, but the government can condemn the property through eminent domain. They're taking it. An example would be in Charlotte many, many years ago, what was it? I think Albemarle Road or maybe W.T. Harris. I think it was Harris. On the east side of Charlotte, it used to be a 2-lane road. And there were these little tiny houses with big, big front yards. And so when that was a 2-lane road and then it was turned into a 4-lane road, where did they get the extra land for those extra 2 lanes? Those people's front yards. So they had to send out a letter, say we're going to condemn half of your front yards for eminent domain because we need to expand the road. It's for the public good. We're going to pay you fair market value for half of your front yard, and there's not much you can do about it. And I just remember driving down through there and seeing a really nice size yard, and then a few months later I drove down through there and saw half of it, they were really close to the road now. But that was eminent domain. The government can do that. That's by operation of law. And then another kind of easement is something kind of weird called a prescriptive easement through adverse use. What the heck? Let's look at that one. Here it is. Think about, anybody heard of squatters' rights? The idea that somebody could come in and just start staying in a property that maybe the owner hasn't been in, and they just start living there. And maybe because of some states' laws, they could stay there long enough and in a certain manner and end up actually getting the property. You ever heard of that? I know. See some faces and you're like, what? That's not okay. Well, this is sort of like that. Prescriptive easement. Let's say that you inherited some land in the mountains. Anybody here literally in the mountains now? I think most of you are more like Charlotte or further east. Say it's in the mountains, it's 4 hours away, almost to Tennessee, and you're like, I do all my living here. I don't even like the mountains. I don't want to go there. Thanks, Granny, for leaving me that acreage, but I'm never going to use it. So it's just there, and you never do anything with it. In the meantime, while you're here and the land is there and you're not doing anything with it, let's say one of the neighbors starts to use it because they're like, well, I don't even know who owns this anymore, but Maybe I'll park my tractor on it because I don't have to put it on my yard. Well, gosh, it's like 2 acres. Let me just plant some corn. Nobody's been around here for years. I've never seen anybody come here. It's all grown over. I'll just maybe mow a section and get it planted. And so for 20 years, every year, that neighbor uses your property and you don't know it. You have no idea. They're not trying to hide their use of it either. They're not doing it in the middle of the night, like going off into the woods and clearing a section that nobody can see. They're using it openly. They're using it continuously for 20 years. They're using it exclusively, just them, not other neighbors, just them. In fact, if the other neighbors drove by and saw them on their tractor on your land, they would just assume it belonged to them because they're just used to seeing them use it so much. No one else uses it but them. It's actual and it's notorious. Notorious meaning if you knew about it, you probably wouldn't give them permission, but you don't know about it, so it's notorious. If all 5 of these characteristics are in place, then after 20 years of using it openly, continuously, exclusively, actually, and notoriously, they could petition the court and say, look, I deserve this property, give it to me. And the court just might do it. That's called a prescriptive easement. That is called adverse possession. Adverse to your wishes. You probably wouldn't like it if you knew about it. You're the owner, right? That's just what it is. So if you knew about it, let's say you did finally go up there on year 19. All they had to do was keep using it the way they were for one more year. But on year 19, you went up there and you saw them using it. And you're like, oh, well, good. I'm glad somebody's putting it to use. Sure, keep on going. You just keep using it. Well, now they can't petition the court to own it because you gave them permission. So the best way to destroy this plan of theirs, maybe they read a law book and realized and had the goal. They thought maybe year 7, they realized, wait, if I keep this up another 13 years, 20 total years, I might get this property and get to own it. But then the minute you gave them permission, you violated the notorious part, and they don't have that going for them. So therefore, their plans crumble. They're not going to get it. It's too late. So what's the best way to keep somebody from taking your property through adverse possession? Give them permission to use it. They're getting to use it, but they would never be the owner because they have permission. You could revoke the permission, of course, too, by the way. So that's just a little nuance. You'll see another reference to this probably in the syllabus. It says if it's a clear title, then it's going to take 20 years of doing it like this. But if there's a cloud on the title, it will only take 7 years. You could acquire the property through adverse possession with only 7 continuous years of doing these 5 things. And then the other little note about this is this does not apply to government-owned property. You can't acquire government-owned property through adverse use. The government's pretty smart to put that little loophole in there. Not possible. And I was thinking of like Area 51. You ever heard of that? Like out in the desert where they keep the UFOs that we don't know that really exist. I'm just kidding. I don't know. I'm just whatever. Acres and acres and acres of government property that they test bombs and things on. You can't claim those through adverse use, right? That easement by necessity, again, another little diagram here. This landlocked property owned by A can't be landlocked, need to have right of way to the street. And so that driveway is an easement by necessity because it keeps that, it fixes that problem of the property being landlocked. How could easements go away? I've seen this on practice tests. The purpose of the easement isn't required. You don't need it anymore. Therefore, you can terminate the easement because the need for it no longer exists. The easement holder becomes the owner. So like in this case, let's say the property owner back here, A, I don't even know if you can see that cursor, A buys the front property. Well, if they buy the front property, they don't need the easement here anymore because all of it belongs to them. So the easement holder becomes the owner. The dominant estate could release it to the servient estate. What if back on this example, what if there's a road back here? What if that gray line up here at the top is another road? It's just that there's a lot of woods and they didn't ever want to go through those woods. So maybe this property owner A says, you know what? I'm tired of this driveway easement. I don't even want to go out this way anymore. Let me clear some of these trees and start making my driveway to this other road back here. And so now I don't need this easement. I have road access to this other road. Therefore, dominant estate could release to the servient estate. They could say, I don't need that easement. You're good. And I'll bet that servient estate that's had that driveway easement is going to be thrilled to get that space back where the driveway doesn't need to be anymore. And then if an easement is abandoned by that easement holder, it could get terminated as well. An encroachment is going over the property line. The best way to figure out what encroachments there might be is to have a survey, because that surveyor is going to do all the research. They're going to go out and remember in meets and bounds legal description, there's a stake. There's probably a metal stake in the ground where they'll use a metal detector. If it's not a flag that you can see, they'll use the metal detector and see if there's a metal stake, a metal rod, and see what the property corner is and read off through the meets and bounds what the dimensions are. And they'll draw those lines. They'll put the flags and sight down through the flag, through those lines, and see if the neighbor's fence is over your line, or if your fence is over the line, or your driveway, or your house, or your detached building, or any sort of permanent improvement. That's the best way. That's the sort of the official way. If there is an encroachment, there's a cloud on both titles, both your neighbor's and yours. Clouds to both titles. So, in a dominant servient estate situation in real estate, can the servient grantee refuse the easement? Can this person in front across whose property the driveway goes, can they refuse to allow the driveway to be there? You got it. Can't refuse it. What was that question, Brian? Would that, what, your address? It probably would. It probably would, yeah. There'd be other things, so that might be a pain, but maybe it's a prettier entrance. Maybe that's something that you would, it'd be worth it to do. I don't know how often that sort of thing is done. It was just the only thing I could think of to give as an example of when the dominant estate might release that easement. Well, that releases chapter 2. Let's go on into 3. We'll talk about taxation. More boring words have never been spoken, but I'll try to make it interesting. Taxation. Here we go. First of all, let me see here. Okay. How are we taxed on our property? If you're a property owner, you got to pay property tax. That's what this chapter is about. And the legislation in place that outlines how we handle property taxation is called the Machinery Act. Testable question. What's the Machinery Act? What does it do? It handles how we handle it. It dictates how we handle taxes. There's some level 2 information in this chapter. There's also level 3, which means there's some math. Got to figure out how to calculate the annual taxes on a property. Not that hard. It won't be bad, I promise. Taxation is the power given to the government to collect money from the citizens so that all these roads and schools can be paid for, can be provided to the citizens. Public things can be paid and provided for. And it's through taxes, some of which is through property taxes. So, very testable. What is ad valorem tax? It's property tax. The word ad valorem is a Latin phrase that means at value, at the value of the property. But be careful. It's not at the value it's sold for. So don't think it means the sale price. It means the assessed value, the value that was assessed by the taxing authority. They're going to say, the government's going to say, your property has a tax value of $110,000. But it may be that you're able to sell your property for $210,000. What it sells for is not probably what the tax value is, and you're happy about that, because usually the tax value is less than the sales price or the market value. You don't mind paying taxes on a lower number, right? So ad valorem is the Latin phrase meaning at the value, at the assessed value. The Machinery Act is the thing that regulates property taxes, and some dates and some numbers here. Every 8 years, the government, the local city, or the county, sorry, I should say the county. Every 8 years, the county can reappraise, can change that assessed value every 8 years. In fact, they're required to. Because over those years, more people moved in, more needs were found, needed more streets. The streets we had needed to be repaved, needed to build another school for all the extra kids that have come in, moved in. Therefore, octennial reappraisal. Octennial means 8 years. They're going to revalue everyone's property for the purposes of taxing every 8 years. A couple years ago, they did it in Cabarrus County. I think the year before that, or maybe after that, they did it in Mecklenburg County. And because values had gone up so drastically in the years before that, people were ticked off because their property values went up like a lot, which really increased their tax bill quite a bit. Their tax values just skyrocketed. When those values come out, when they do reevaluate, you can appeal it. And sometimes as a broker, it's good to reach out to your friends and family and say, hey, do you need my help in appealing your property tax valuation that just happened? I'll be glad to run some numbers to do a market analysis or pull some comparable sales and give them to you that you can use when you do your appeal. Nice way to sort of provide a service to people. Because how can we convince the government that they're wrong? Only with proof that your house is not worth as much as they thought it was. So that's every 8 years required. It might be that things increase so much in a certain part of town that the government can say, well, this fourth year from the octennial reappraisal, 4 years later, they could do a horizontal adjustment. That's an optional thing. They may or may not do it. Again, probably up, but it's going to be a horizontal adjustment to a certain part of town maybe that has seen more growth than the others. And they have that right. And then there's a number that's adjusted every year, possibly. Not automatically, not for sure, but it could be that they change the tax rate. It's probably not going to happen every year, but it could. It could be adjusted annually. And when would that property tax rate be changed? In July. If it's going to be changed, they're going to tell you, as of July, here's the new tax rate. Well, you have a county, whatever county you're in. Tell me in the chat what counties you're in. Give me some counties. Got a Union, probably have a Mecklenburg, got an Iredell. Yep, there's a Gaston. Wow, we got a nice representation. And then what cities are you in? Or if you're not in a city, just say county only. Got Waxhaw, Mooresville, Mecklenburg County, Charlotte. You could be in the county, but not be in a city, right? So if you're in Cabarrus County, but not the city, that means you're in the county, but you don't live in Midland, Harrisburg, Concord, Kannapolis, or Mount Pleasant. But your mail might say one of those things, but you're actually not in the city limits of any of those 5 cities or towns. You could be in Mecklenburg County and not be in Charlotte or Huntersville, although that would be pretty difficult because those cities have really grown and probably taken most of the county space. So the dark blue here is county, but the city is in light blue. There's no way, however, that you could live in the city limits and not ever be in the county. If you're in the city, you're in the county because the city is in the county. Why am I talking in circles? Because part of the way we calculate your tax bill is depending on the tax rate. And there's a city tax rate and there's a separate county tax rate. So if you're in the county but not the city limits, then all you have to pay is the county rate. You with me? You don't have to pay the city tax rate because you don't live in the city limits. However, if you live in the city limits, then you have to pay both the city rate and the county rate because you live in the city and the county. Follow me? Okay, let's look at some dates and then we'll get around to the math here in a second. In July, if they're going to change the tax rate, that's when they'll do it. That's when it will be set for the year, in July. In August, they'll mail out the tax bills because when can you start paying your property tax? As of September 1st. You need to know that. When is property tax due and payable? September 1st, every year. What happens if you don't pay it on September 1st? Nothing. You have all the way until December 31st to pay it. No penalties, no late fees. It's fine. Most people do, including lenders who pay it for you because you send in your house payment and including a little bit toward taxes. So every year when the tax bill comes due, the lender sends it in for you many times, quite often. And you better believe that lender wants to keep the money in the account as long as possible. They're not paying the bill probably till November or December. So that part doesn't matter. But as of September 1st, it is able to be paid. This matters later. September 1st or later, you can pay the tax bill. Now, some of you pay your bills the first day they're due. Good job. Good for you. My wife is one of those. She pays right away. I pay later. Well, she'd probably pay on September 1st or that week. I'd probably pay on December 31st or that week, right? January 1st, if you haven't paid the taxes by December 31st, then on January 1st, a tax lien will be filed against your house for those unpaid taxes. Now you've got a lien. If you don't pay your taxes by January 5th, that's the deadline to pay those past due taxes. Now, if you pay them after January 5th, it's going to cost more. Penalties, some sort of late fee. And then if you haven't paid your taxes by January 31st, then eventually in the next few weeks, the taxable property, your property is going to be listed in the paper or online for the local county saying that your taxes are delinquent. We'll get more about taxes in chapter 12 when we deal with closings. But here's a little timeline. Again, July is when the rate is set. September is when they're due and payable on the 1st, but you have until the 31st. January 1st is when a tax lien is filed because you didn't pay them. January 5th is your deadline to pay them without penalty. January 31st is when, from that point forward, your house could be listed, your address could be listed as having taxes unpaid. And if you'd go long enough without paying your property taxes, you could lose the property. They could foreclose on your property because you didn't pay your taxes. There are tax foreclosure sales. And remember, the property taxes come first. We saw this graph already, this slide already. So how do taxes work? Okay. Let's take a look at this math. Level 3. First of all, keep in mind, this is the extent of algebra that you need for this course. Something you can really do in your head as far as the relationships. You know that 2 times 3 is 6. So if we put those things in a different position, the 2 and the 3 on the bottom, whatever's on the bottom of this T formula there on the right, the two things on the bottom get multiplied together to equal the item on the top. So let me get ready for my little calculator here. Okay, all ready. So 6 divided by either thing on the bottom equals the other thing on the bottom. The thing on top of this T formula divided by one of the things on the bottom gives you the other thing. So if you know whatever the 6 is and whatever the 3 is, you can use it to calculate the thing that is the 2. What does that mean? Let's look at it as it applies to taxes. There are two ways you could see the tax rate. Some cities will use mill rate. Other cities will use dollars per hundred. Yes, good question in the chat. Can you buy somebody's property by paying their unpaid taxes? You could. The tax lien foreclosures, you could pay off those taxes. You could get the property. And there are investors that do that. If your city uses mill rate to calculate taxes, they'll say that taxes in this city, properties in this city are being taxed at 15 mills. 15 mills. So ignore this for a second. Let's look at this one. If we have a tax value of a property, the assessed value is the same as the tax value, by the way, right? Tax value equals assessed value. You'll hear me say either one. You'll see the test refer to it either way. It means what you're being taxed on, the value of the property on which you are being taxed. By the way, it's probably not what it's worth to a buyer. You'll probably make more than that when you sell it, in other words. So if the assessed value is 185.5 and the mill rate is 15, or the rate at which you are taxed is 15, here's the question. How much will you pay in taxes in dollars for the year? We need to convert that mill rate of 15 into a decimal in order to do the math that we need to do next. So to get the proper decimal out of this mill rate, we need to move the decimal that's already there. You can't see it, but it's after the 5, right? Any whole number in the world that does not have a decimal is understood to have a decimal right after that far right number. So that's a 15, but it's also a 15.0. You with me? So there's our decimal that you can't see. If you move that decimal after the 5, if you move it over 3 places to the left, that's the same thing as dividing 15 by 1,000. And that's what you have to do to put mill rate into the decimal version that you need to do the math with. That'll make more sense in a minute. So we're going to use this T formula. The rate is on the bottom. By the way, the rate is always on the bottom. No matter what kind of math we're doing, if it's got a rate involved, it's going to be one of those bottom numbers. The bottom of the T formula is going to have, if there's a rate, it's going to have a rate. It won't be on the top, it'll be on the bottom. So the mill rate times the tax value or the assessed value, multiply them together, is going to give you the tax bill, the annual taxes that are due. 185.5 on the bottom, multiply it by that decimal version of 15 mills, and you get an annual bill. That's your taxes. That's how they calculate your taxes when you own property. This person has to pay $2,782.50. $2,782.50 is their annual tax bill. So, step 1, pick the right T formula. Here it is. Step 2, enter in the numbers that you know. We knew the tax rate and we knew the mill rate. Step 3, divide the mills of 15, divide them by 1,000 in order to turn it into this decimal, 0.015. you can do that math in your head, because all you have to do is realize the decimal is after the far right number, and move it 3 places to the left, because 3 zeros are in 1,000. When you need to divide anything by 1,000, find the decimal in that number and move it to the left 3 spaces. You just divided by 1,000 without a calculator. So let's look at this one. The assessed value, they're telling us, is 75% of the market value. Whatever it sold for, they're telling us in this question that the assessed value is 75% of what it sold for, and it sold for $340,000. So if we determine 75% of $340,000, that's going to be the tax value, also known as the assessed value. So let's plug it in. Here's what a T formula would look like to accomplish that goal. Take the assessed value percentage. 75% of what? 75% of 340,000. You will literally put in the number 75 and then hit the percent sign on your calculator. 75%. Or, because percent, the word percent literally means per hundred, because cent, think about C-E-N-T. Cent means 100 cents in a dollar. You can remember it that way. 75% is 75 per 100. So where's the decimal in the number 75? It's after the 5. Per 100, there's 2 zeros in 100, so move the decimal 2 places to the left. 2, not 3 this time, because we're dividing by 100, not 1,000. If none of that made sense, ignore it. Forget it. You don't need it. I'm just giving you a little bit of insight. It might help. It might click. But I'll also just show you how to plug it in the calculator, and you don't need to understand the why. So, market value on the bottom, 340. Multiply it by 75%. And now we know that the assessed tax value is $255,000. That is the number that we're going to use to determine what your annual tax bill is for this property. Now that we know the tax value of $255,000, let's keep going. This item in blue at the bottom is for those of you who are like, T formula, that's terrible. I don't like that at all. Give me just a normal straight line algebra equation. If that's your thing, have at it. Enjoy it. Do what works for you. Don't worry about knowing everything. Just pick the way that works for you. So we know now that the tax value is $255,000. We've just did that. What they're giving us next is that the tax rate is 13 mils. If the tax rate is 13 mils, what are the annual taxes? What's that annual tax bill? Well, there's our original T formula. Take the tax value we just discovered of $255,000, multiply it by the 13 mils in a decimal version. 13 mils divided by 1,000 is 0.013. 0.013 times the tax value shows us our annual bill, $33.15. So, this thing called mill rate. I don't know. Memory aid, I might think million. When I think of the number 1 million, I think of 2 sets of 3 zeros. And maybe that'll help you remember when you see mill rate, divide by 1,000, because 1,000 has 3 zeros. I'm grasping at straws, looking for some way for it to help you remember it. When you see mill rate, you need to divide by 1,000 to get it into a decimal, so that you can then multiply it by the assessed value. When you do about 10 of these practice problems, all of this won't matter. You'll be like, oh yeah, that's what I do. No big deal. You'll get this. You'll get it. So 13 mils divided by 1,000 is the decimal version we need, 0.013. What you could also do, that's the proper way, but that 255 on the bottom, you could just multiply that by 13 mils. Forget about the decimal version, but then do the decimal part later. So 255,000 times 13 is a big old number, and then divide all that by 1,000, and you'll get to the same place. It'll work the same way. So somehow or other, you need to divide that bottom row by 1,000, whether you do the mill rate and then multiply, or you do the whole thing first and then divide by 1,000. It kind of doesn't really matter. How about this one? Remember, mill rate is only one of the ways that they might use to calculate taxes. Let's finish this out and then we'll call our last break. The other way a town could handle their tax rate is through dollars per $100. The way that's worded is the tax rate is $1.30 is due to the government for every $100 of tax value. You with me? How many $100 of tax value do you have? Well, multiply that number by $1.30. $1.30 per $100 of tax value. That's what we're saying when we say $1.30 per 100. That's what that means. So here we have property is valued at 75% of market, and the market is 340. We just did that to be nice. That means our tax value is still going to be the 255. That's unchanged. But this time the property is in a town where they use a tax rate of dollars per 100 instead of mill rate. Dollars per 100 versus mill rate. What do you need to know? One of them you divide by 1,000. That's mill rate. The other you divide it by 100. Done. That's the only difference. The dollars per 100, that just means 1.3 divided by 100. We need to move this decimal 2 more spaces over. So it looks like this. That $1.30, we see the decimal. Find the decimal. If we're dividing it by 100, we're just going to move it 2 places over to the left to get our decimal version of 0.013. You can also do it in the calculator. Put in 1.3 in the calculator and hit the percent sign, and it'll show you 0.013. And so there it is. You'll notice that $1.30 per 100 is the same thing as 13 mils. It's the same decimal because it's just a matter of moving it around a little bit. So a town, let's say Huntersville, gives it in mill rate. I don't think they do. I think some of the towns further into toward the east of North Carolina use mill rates that I've seen. But anything around here, Charlotte, 50-mile radius that I've ever dealt with has been dollars per 100. But the mill rate, 13 mils, is the same as saying 1.3 or $1.30 per 100. So just know that if you see mils, divide by 1,000. If you see dollars per 100, divide by 100. And that's what it looks like if you wanted to plug it into a T formula. $1 per 100, $1.30 per 100 divide by 100 gives you the proper decimal version. Or you could just move it 2 places to the left. So market value times percent of assessment. If they give you that on the test, that means that's how you get the tax value or the assessed value that you need to calculate the tax bill. Take that assessed value, multiply it by the tax rate, whether it's mils or dollars per 100, and that will give you your annual taxes. Annual, per year, that you got to pay every year. There are a couple of cases in this course where we don't need yearly taxes. What we end up needing is monthly taxes or even daily taxes. So in order to take our annual taxes that we just calculated and convert them to monthly, divide by however many months are in a year, so divide by 12. But here's what's different. For your purposes, in this class and on the exam, every month has 30 days. Real Estate Commission says, let's not burden them with that craziness about 31, 30, 28, 29. For calculating stuff in pre-licensing and on the PSI exam, 30 days a month. And if you take 12 months and multiply it by 30 days per month, that's 360 days for the year. So if you need to calculate daily taxes, divide by 360 in pre-licensing class and on the test. Let's have a break. I'll see you back, and we'll do a couple more tax problems from scratch.
The autumn leaves drifts by the window.
Okay, let's see here. Can you see that green board? Okay. Good. Okay. All right, got a problem here for you. Let's take a look at it. I'm going to give you a second and let you see what you can do with it. Then we'll walk through it. Property sold for $780,000. Tax value is 85% of that. 85% of market value or sales price. The tax rate is given in 9 mils. So what's the annual tax bill in dollars? I can get that up, zoomed out a little more for you. Get it nice and legible. What we're going to need is to fill in this T formula. And here it is for taxes. The tax rate on the bottom. The tax or assessed value on the top will give you the annual tax bill or the annual taxes to be paid. So, do we know the tax rate? That's 9 mils. And we could go ahead and put this into decimal format, meaning divide it by 1,000. So over here on this calculator, we take that 9 divided by 1,000, and that gives us the decimal version of 0.009. You could also take that 9 mils and understand that it's 9.0 and go 1, 2, 3. 0.009. So same thing. And we also need the tax value. Well, we know it's this. It's 80% of the price. 85% of the 780. So we'll take our 780 that it sold for, multiply it by 85 and hit the percent sign. That means our tax value is 663. And if we know both of these numbers on the bottom, we multiply them together. So our annual tax bill is $59.67. How's that? Step 1, get the tax value. They might give it to you. They may not make you do this nonsense. They may or they might not. You just need to recognize that you're not going to calculate taxes based on the sale price or the market value. You're going to base them based on the tax value or the assessed value. So however you need to find that assessed value, you got to do it. And so you'll plug that assessed value in down here. You'll recognize, look for the tax rate. In this case, they gave it as mils. That goes on the bottom. And you know if it's in mils, divide by 1,000 to put it in the proper decimal. Multiply them together to get the thing on top. Okay, how about this one? Property sold for $567,000. Tax value is 90% of the sale price or of the market value. This time the tax rate is given this way. There's a city rate and a county rate. The city rate is going to be this one up here. Let's say the city rate is 0.92. 92 cents per $100 is the city tax rate. The county rate is let's say 67 cents per hundred. Per $100. Per $100. And you need one more piece of information. When they give it to you, when they tell you that the two rates, there's a city and a county rate, you also need to know this. The problem will say maybe this: property is in the city limits. That's where it's located. So if this is the county and here's the city, property's not out here, it's in here. That means we need to pay city and county both. So what's the annual tax bill? Step 1, get the tax value. Tax value first. It doesn't matter, but I'm just giving you steps. Tax value is 90% of the sale price. 567 times 90%. 510, 300. We're going to multiply that by the rate, but what rate? You tell me. Property is in the city limits. Can you be in the city without being in the county also? Impossible. Therefore, if the property is in the city, you're going to use both city and county rates combined. So we're going to add 0.92 with 0.67. So the total tax rate is $1.59 per $100 of tax value. That means we're going to put this $1.59 here on the bottom, but we're going to make sure to divide it by 100. $1.59 divided by 100 is the decimal 0.0159. And then we're going to multiply that decimal by the 510, 300 that we figured out a minute ago. This tax bill every year that is due on September 1st is $81.13 and 77 cents. Is that okay? The little nuance here was, since it's dollars per 100, let's make sure we know where the property's located so we'll know which rate or maybe both rates to use. We will never only use the city rate. You would never only use the city rate because you can't live in the city without also being in the county. So it's either going to be county rate by itself or city and county rate together. Is that okay? I'm looking at faces. If it had said this, the property is outside the city limits, then what would we have done? Which rate would we use? We would just use that county rate. So we would say 0.67 cents per $100. Take 0.67 divided by 100. That's the decimal we would use. Multiply that by the tax value. Taxes are a good bit less. Went from like 8,000 down to 3,400. Let's go live in the county instead of the city limits. How about that? Oh, but we got to have a septic tank if we're in the county. Not necessarily, but maybe. There are positives and negatives, aren't there? Takes a little longer to get to the wherever. We okay with that? All right. That is yeah, that's 3. That's all there is about 3. Let's get into 4. 4 is called transfer of title. It means a title or a deed going from one to another. And oh, okay, there we go. All right, there we are. Juggling windows. Okay, we're back. So, transferring title, selling it, right? We're giving the title to someone else in exchange for money. Probably. We could give it to them for free, like grandparents could give it to a kid or a grandkid through gift, but that'd also be a transfer of title. But we're conveying the property from one owner to another. And our objectives here is to discover the methods of doing so, the essential elements of the title itself. In real estate, the title is called a deed. A deed, like a title to your car, but it's real estate, you're going to call it a deed. Just the word deed by itself. And then we're going to see what various types of deeds look like. We're going to do a little bit more calculation called excise tax. This is the sales tax that the seller has to pay. The seller pays it based on the purchase price, not the tax value. So we'll see the differences there. And then we'll talk about title insurance. So one word you'll see used in this topic is alienation. It means you are distancing yourself from the property. You're selling it. You're getting rid of it. You're alienating yourself from it. That's all that means. So alienation, selling or giving away. You will no longer be the owner some way or other. And it's going to require describing the thing you're selling. Got to make sure you're selling the right thing, that they're getting the right thing that was intended. And so as part of the sales contract, which is going to be the legal instrument we're using to sell the property, we need to have the legal description on there. And by the way, the street address ain't it. What is an adequate legal description when selling property? Test question. Street address is not it. What are the 3 types of legal descriptions we could utilize? There we go. Meets and bounds. We like that one a lot. Reference to a previous plat, a recorded plat, and then reference to a prior recorded deed. Any of those 3. Now, the contract is going to have other ways to identify as well, but it has to have at least one legal description. It'll probably also have the tax parcel ID number, which is like a 9 or 10-digit number that references where you can find the tax information. But that is also not a legal description. That is also an informal reference. Basically, you want to put on the deed legal descriptions. You want to put on the contract everything you can possibly use. The deed is also going to have the address, even though the address is not formal like a meets and bounds would be. But it's still well known. It's how we know where the mail goes. So street address is informal. Legal description is the exact description of the real estate. And what we need to put on the deed is an essential element. And there's a handful of them. The essential elements of the deed include the legal description. So that is one of them. We'll see a whole list of essential elements in a minute. What's an essential element of a deed? Legal description. Makes perfect sense. You need to know what's being conveyed. And there's that part. We already knew that because you're so smart. Meets and bounds, reference to a recorded plat, reference to a recorded deed. And we don't do this in North Carolina, so this is not a legal description that we will ever use. Government rectangular survey. But they do in most of the country, except for the 13 colonies. Okay, so that meets and bounds description. Back in the day, these meets and bounds descriptions would be like, they're like paragraphs. They could be several pages long. And they literally would say things like, starting at the rock at the corner of North Street and West Street, proceed 100 feet, 13 degrees southeast, till you get to the stream, and then go west 300 feet or yards for 13 degrees southeast. I don't know if these directions make any sense, but they're going to have all of those types of things. And what's in that description that they're referencing when they say rock and stream and street corners, road intersections, those things are called monuments. Monuments meaning they're permanent, they stay in place. So we can use them for describing the property because we know they're not going to leave. They're going to be there for a while, hopefully forever. Well, we don't so much use rocks and streams and streets anymore. When a property is surveyed now, the meets and bounds legal description is going to probably say at the stake located at this location, they'll go into it, because the surveyor is going to drive a metal rod into the ground. And then they're going to put a wooden stake with a flag on it at that location. But the metal rod is never going anywhere, hopefully. Now, some disgruntled neighbor could maybe come out, find it, and pull it up out of the ground. I mean, it's probably 2 or 3 feet long. It's pretty sizable. It's meant to be there to identify this property corner forever and ever. So that's the point of beginning. The first thing that you mention in the meets and bounds description is the point of beginning. And so that's a term that you need to know about meets and bounds. When we're tested on meets and bounds, you just need to know vocabulary words. Just know some words related to it. Because "13 colonies use it." That is the preferred method of using, of describing property, legal description. The rest of the country does not. The rest of the country uses a way that was devised by Thomas Jefferson and the government in those days. And it's a grid pattern, government rectangular survey system. That's something that you could be tested on the national portion of the exam, by the way. And we'll get into that too in a minute. But really, for both of these things, you just need to know vocabulary words, be able to answer questions about it. What are the common words involved in a meets and bounds description? Well, point of beginning. By the way, the point of beginning needs to also be the point of ending, because we're making our way and describing the perimeter of this property, and it has to be a closed shape. It can't be an open shape. Like in the alphabet, the letter C is an open shape. The letter G is an open shape. The letter O is obviously a closed shape, right? Another word in the meets and bounds description is monument. It's those things that are fixed objects to establish the boundaries. The word meets means distance, like meter. A meter is distance, so that's how you can remember that. And then bounds means in what direction are you bounding? Like a dog bounds across the meadow. You're moving in what direction? So distance and direction is what meets and bounds is talking about. So if we were describing this property, we might say that the point of beginning is here, this upper left corner. Proceed 250 feet east, and then 500 feet south, and then 250 feet west. They would reference whatever these corners are, whether it's another metal rod in the ground or some other kind of monument in the olden days. And then ending back at the beginning. The point of ending must be the same as the point of beginning. Now you have a nice closed shape that somebody owns. And there's the distances and directions, feet and directions. And then all those points are monuments. So point of beginning, point of ending, meets, bounds, distance, direction, monuments. The test question said, what are some of the terms associated with meets and bounds? Would you be able to answer that or recognize them on a multiple choice list? Give me a couple terms. Please and thank you. Beautiful. It's 9:05. I understand. So participation can really help with consciousness. Beautiful. Meets, bounds, monument, point of beginning, point of ending, distance, direction. All those have to do with meets and bounds. Now the rest of the country. The original 13 colonies plus Texas tend to use meets and bounds, but the rest of the country uses government rectangular survey system from 1785, the founding fathers. The idea was the Old West, to them, the New West. People go claim territory, claim land, and create towns. And back then they called them townships. Little towns like the Old West duel in the middle of the street, the old Western towns. They said, the founding fathers said, let's be organized about this. Let's come up with a grid system. So every town is comprised of grids. And so that's kind of how this works. That grid is going to have north and south lines, up and down, and left, right, or east-west lines. Some of the names of these lines are these. The main one in any particular town or section, we'll see what the difference of that is in a minute. The main is the principal meridian. The main horizontal line or east-west line is the baseline. The other lines that are going north-south are the range lines. So meridians, principal meridian, and range lines are the vertical or north-south lines. The east-west, left-right ones are the baseline and tier lines. And the squares that these things create are the townships. Those are the towns. Inside that town, it looks like this. Any given township is 6 miles by 6 miles square. And so when you make a grid out of 6 miles square, 6 this way, 6 that way, each of those squares that it creates is a section. So there are 36, lower right corner, 36 sections in a township. This is the extent of what you need to know for government rectangular survey. You don't need to be able to use it. Some test questions, some quiz questions or review in the back of the book might reference which section is this, and it's the northeast quarter of the southwest quarter of the this or the that half. You don't need to be able to do that anymore. They used to make you do that, but you don't anymore. You just need to know these words. So there's 36 sections. How, if a township is 6 miles by 6 miles, 6 miles on one side by 6 miles on another, then how big is a section? What's the dimensions of a section? Any guesses? There you go. 1 by 1. A section is 1 mile square. A township is 6 miles square. And so they start this is the way it is laid out on every one. So they started at the upper right. Number 1 is the upper right, and you progress to the left all the way over to 6, and then you don't come back to where you started to go continue with 7. You just bump over, as you can see in the upper left corner of this thing. I think. Am I showing you the right thing? Okay, yeah, good. Gosh, brain dead for a second there. Now, why did they do it this way? Well, you're going to feel silly when I tell you, because this is going to be so relatable to everyone. You're going to be like, oh, why didn't I think of this? Of course, this is how you would lay this out, because you and I would lay it out this way. So you know how it is when you're plowing a field, because that's what we all do in our spare time, right? You start plowing the field, you go all the way across the field. You don't go back to where you started. You just go over a little bit and work your way back and plow back the way you came, but not on the part you already plowed. So if you just progress over, down a little, over, down a little, over, down, that's the quickest, most efficient way to plow an entire field. I know that you would never have thought of that. I wouldn't have either. I don't plow fields, but that's what they did. And so that's how they came up with how these townships are numbered. And so the number one section in any given town is always going to be upper right, the northeastmost section. And the 36th section is always going to be the southeastmost section, the lower right, right? That way it's predictable. Any town you go in the Midwest, the legal description, you're going to know kind of where you are. What they also would do is always put the government services in the 16th section of a town or a township. So the school, the sheriff's office, the jail, the government buildings would be in number 16. And the idea there is it's centrally located. I guess they could have picked 15 or 21 or 22, but it's pretty central to the whole township, right? So, some terms to know for government rectangular survey. Meridians and ranges are the ones that are vertical north-south lines. Baselines and tiers are the ones that run west and east. A township dimension is 6 miles by 6 miles for a total of 36 sections. A section dimension is 1 mile by 1 mile. And if you figure up the amount of acres in a section, there are 640 of them. How many acres? How big is a section? 640 acres. How do we do that? Let me show you that. Okay, here's our section. It's a square. Trust me, it doesn't look like one, but let's say that is a square. 1 mile by 1 mile. Does anybody, for some reason that I can't imagine why you would, anybody happen to know how many feet are in a mile? People don't know that. But does someone? How many feet are in a mile? One mile has 5,280 feet. So if you run a mile, you've just run 5,280 feet. So that's how many feet are on one side of a section. And if we take those feet, 5,280, multiply by each other, that gives us this big old number. 27,878,400. You do not have to know that. You don't have to know it. I'm getting somewhere here. If we take that number and divide it by the number of square feet in a mile, which I'll teach you in a minute, which you need to know. 27,878,400 divided by the number of square feet in an acre. An acre. That gives us the 640 acres that are in a section. So how did I get that? How many feet are in an acre? Here's how to remember it. Here's my favorite way to remember it. 1 acre has 43,560 square feet. Because an acre is the dimension, is the volume in feet of a parcel of land. So the way I remember it is 4 little old ladies driving 35 miles an hour in a 60 mile an hour zone. 4 little old ladies driving 35 and a 60. That's how many square feet in an acre. You need to be able to convert acres to square feet and back again for the test. Yeah, I get you, Brian. So there was that, and we'll do some conversion, some acres to square feet conversion another time, but let's finish with this government rectangular stuff. So there, know these terms for the government rectangular survey system. That's about it for meets and bounds versus government rectangular. It's 600 government rectangular. A section has 640 acres. Tier lines and meridian lines, and a township has 36 sections in it. A township is 6 miles by 6 miles. A section is 1 mile by 1 mile. There's range lines. So, in North Carolina, the most favored form of legal description is meets and bounds. What are the other ones? If somebody recorded a deed to the property previously, it's also going to have a legal description in it. And so if you just reference the previous deed, reference to a last recorded deed, that will satisfy your need to create the deed on this sale. The attorney can just reference the last deed as long as nothing has changed. As long as the legal description back there at that other deed from when it sold before has remained unchanged. And it'll be like, see the deed located at book 437, page 392, a book and page number. Because what's happening is they're recording the deed at the Register of Deeds office at the courthouse. Online, probably, but it's also available in person. You could go there. There's a physical location. And so that recording office is where we put it on the public record. So you can look up people's deeds right now. When we finish class, either your own deed or your neighbor or your parent or your friend, if you know their address, look up the GIS for the county they live in or the property is in, and you can find a search function to plug in the address, and it'll show you the deed. It looks like a scan, probably a poorly scanned document, and you can read it for yourself. And that deed will probably reference either meets and bounds or another deed before it for the legal description, or this. It could also reference a recorded plat map. Plat map just means a map showing the streets and all the properties within it. And it's recorded. It's on the public record. Everybody can see. It's showing, in this case, the location and boundaries of these lots. And so lot 7 of block E of Far Hills Estates, this is Far Hills Estates. Where's block E? Can't really tell, but I think it's this, it's this middle section right here, block E. And so lot 7 of it would be, I can't zoom in, but I think it's, oh yeah, it's shaded poorly. It's that one. It's right about there. But this plat map would need to be recorded, obviously, in order for it to be a legally acceptable description. So it's got to be a recorded plat map. When the developer had this place made, when they developed this neighborhood, they had to create a plat map, have one made and record it in order to even sell any property. Before they could close on any of the sales, anybody who wanted to buy one, before they could have the actual closing, where they got money in exchange for possession of the deed, they had to have a recorded plat map first. Otherwise, it would have been an illegal sale. So these recorded plat maps are another of the 3 possible ways to have a legal description in North Carolina. There's other ways to describe property that we also are going to want to use if we have them, but they can't be in place of a legal description. They would just be extra. Street address, of course, that's how most people know the property. Parcel ID. The street address, city name is just for really mail purposes, right? So part of what happened to create this plat map was a surveyor went out and cited the lines. They found the stakes, they put them in. They might have created them because they realized this is a 10-acre parcel that this developer wants to split up into these house lots. And so they created them. They decided, let's measure over from here, and that's where this stake is going to be another 50 feet or 90 feet or whatever that is. It's going to be the next one. Am I showing you the right thing? Or have I been talking without showing you the right thing? There we go. Oh, no, it didn't matter. Okay, I'm with you. Because you're seeing, I shared it on Zoom. That's the main thing. Scared me there for a minute. Thought I was just yapping on without you seeing what I was showing you. So a survey, when you see those people out there with those yellow cameras or scopes and another person with another yellow tripod in the distance, they're checking dimensions. They're citing these lines and they're verifying the lot dimensions. They're looking for also they're locating easements and encroachments. So a good survey is going to have a reference to all of these things. They're going to show setback lines. A survey is going to show how close to the property line you're allowed to build. You may not be able to build all the way to the edge of the line that you own. You might have to build within 10 or 20 feet or no closer than 20 feet or 40 feet. Depends on the city, depends on the town, depends on the rules and regulations there. And a surveyor is identifying on that survey the lot lines, the setback lines, the easements, the utility easements, the driveway easement, any sort of encroachments. It'll be the way you discover that your neighbor's garage is on your line, on your property, over your line. And also flood zones. The surveyor is going to do the research of all of these things and draw on that survey that there's a flood zone maybe. So that's the best way to find out what's going on with the property dimensions. Always advise to your client to get their own survey done. We'll learn why in a minute, or maybe tomorrow. It's a legal document, by the way. Don't try to explain the survey to your client. I know it's just a drawing, and it's pretty clear cut, this many feet over. But to explain that or to draw it or to take out your business card and make a little hash mark because that represents 10 feet and to figure out how to lay out the fence, none of that is in your field of expertise unless you are a surveyor. You could be in trouble. That would be called interpreting the survey, and it's legal stuff, legal document. So unless you're an attorney or a surveyor, don't give survey advice. Just say, hey, here's the survey. And they will say, well, what do you think we should do for the fence? Good question for the surveyor. I'm not your guy or the fence person. So as brokers, we need to know when to stay in our lane, and that would be one such place. That deed, again, like the title to your car, is the main document that literally conveys the property from you to the buyer if you're the seller. It's the evidence that you own it. Therefore, you're giving it to them. But you're going to have a deed created every time there's a transfer of title. It won't be the same deed. The same deed you got from your seller is not the one you're going to give to the buyer because it has to have the names of the parties on it. The one you got from your seller said that the grantor was John Smith and the grantee was you. But the one you're going to give to your buyer says that the grantor is you and the grantee is whatever their name is. You're the grantor, you're giving the deed. They're the grantee, they're receiving it. And that deed is the thing that identifies the property through the legal description, but also explains the bundle of legal rights. It represents that bundle of legal rights. And it's the proof. It's your proof that you own it. So, some weird legalese here. Under what's called common law, title has officially considered to have been transferred from one party to another when the deed is delivered to the buyer and the buyer has accepted it. Now it is considered legally under common law to have transferred. Deed has been transferred. So seller is going to receive the money and then in exchange hand the buyer the deed. Delivery and acceptance. Voluntary acceptance, by the way, not forced at gunpoint acceptance, right? Delivered and voluntarily accepted. But in North Carolina, it takes more than the voluntary acceptance for it to be considered done, for it to be considered a closing. Acceptance is only considered official when the attorney has actually recorded the deed at the courthouse or online, the online registry of the courthouse. Recordation is the thing that constitutes acceptance in North Carolina. Why does this matter? Does anybody notice a friend or maybe yourself had a closing on a Friday? Maybe somebody wanted to do it on a Friday because then they could have the weekend off work to do the move or the bulk of the move. Well, that's all well and good. But what if the closing was supposed to be Friday morning at 10? That's a pretty good choice. However, some last minute things happen. The lender is behind. Maybe the lender screws something up. Maybe it's not even their fault, but for some reason there is a closing delay. So 10 o'clock comes and goes. It doesn't happen. The lender says, oh, we'll get this cleared up. We'll do a closing at 3 on Friday afternoon. Everybody's still upset. Everybody's nervous. But the attorney, thankfully, has an available slot at 3. Sometimes that's a problem because the attorney's busy. Well, we do it. We meet at 3. The seller signs their documents. The buyer signs their documents. But because the buyer has a lot of questions and it just takes the time it takes, because once the buyer signs everything, then the attorney takes that packet of papers, sends it back to the lender, and they verify that everything looks right. Then they finally acknowledge, yes, you can release the funds. So that might take until after 4 p.m. on a Friday. The problem is the Register of Deeds office closes at 4 p.m. Even the online version. Because recording your deed online still requires a human on the other end who is literally doing the recording. In fact, it's not like paying your bill online. You can't just go online and do the recording of the deed and just hit the button and it'll do it immediately. You've got to wait in line. There's a queue. And they'll say you're number 14 in the queue because the other person, that Register of Deeds employee, is looking at what the attorney has sent them, checking it to see if any additional liens have been placed against the property in the last couple of weeks since the attorney did a title search earlier, which we'll learn about later. And they're making one last check, one more time, because what could have happened? The seller could have had another lien put against the property and not even know it. Maybe another mechanic's lien, a plumber that didn't get paid that finally was still within the 120 days, put a lien on it yesterday. The attorney checked it 2 weeks ago, but since 2 weeks ago, just yesterday, someone else put a lien on the property. Well, we can't transfer property to a new buyer with a lien attached without their knowledge. Therefore, the closing attorney, paralegal, is going to be recording that deed, and the Register of Deeds employee is going to check to see if any additional liens have been put on the property at the last minute. At that point, once they verify, nope, no additional liens, boom, it's recorded, stamped, boom. Now it's official. Now it has closed. But back to our example, it's past 4 o'clock. Nobody's there to record it. We had a settlement. A settlement just means everybody signed the papers. Settlement is different than a closing. So we had a settlement on a Friday, but now it's not closable because it's not recordable, because nobody's there to record it, because that stopped as of 4 p.m. So we had a settlement on Friday, but we're going to probably have a closing on Monday if you're lucky, because that's the next available time the Register of Deeds will be open when they can record the deed. So in North Carolina, acceptance occurs at the point the deed is recorded. Testable item there. So watch out for that. We'll talk more about that in chapters 9 and 10, and we'll talk more about this. We have quite a bit more, about 2/3 more in this chapter. So I'll see you tomorrow. Put your name in the chat for me. Let me know if you have any questions. I'll see you then.